Hey, welcome to Dolly Talk. How is everybody doing? All right, we have start of day two today. Hopefully, we'll get through it. Gonna hear from some more officers, find out if he testifies, and all that good stuff. So, trying to. Some people know how it ends, so try to avoid spoilers if possible. All right. I just gotta sort some stuff out. Thank you, Louise. You're the best. Hey, Jim is here. Knit a wow. Scott, I was over with earlier. Paul is here. No one has, but just in case they do. 2 deputies and state rest. Okay. Excuse me. All right. So, Hey, Johnny.
Ladies and gentlemen, welcome back.
Yay,
Was everybody able to follow my instructions and admonitions since we saw each other last? All right. Sorry, call your next witness.
We will call Deputy Mlen.
Sorry for the testimony of these proceedings.
Good morning, Deputy.
Good morning.
Can you please state your name for the record and spell your first and last name for the court report?
Yeah, Deputy Levi McClellan,
Boy,
LEVI,
corn-fed Ohio boy.
MCCLLAN.
And just for the record, what is your occupation?
Deputy Sheriff for Warren County Sheriff's Office. I work for the Deerfield Township Post.
And how long have you been with them?
About two years.
And has that all been primarily road patrol,
Yes.
going out on calls, traffic offenses, that sort of thing?
Yes.
Okay. Did you ever have any prior, like any type of law enforcement experience prior to Warren County?
Yes, I worked in Montgomery County Jail for about 2.5 years as a corrections officer.
That had been a little interesting.
It was.
I'm going to take you back to Saturday, November 9th of 2024, about 11:30 or so in the evening. Would you have been on duty as a Warren County Sheriff's Deputy on that date and time?
Yes.
And would you have been in a similar type of uniform in a MR Cruiser?
Yes.
Can you tell us what shift had you been working that day?
I was assigned day shift. I think we had maybe a call off, so I was working double time or double shift.
God, is the prosecutor
so as of 11:30
smitten
that
with
night,
him?
how long had you been on duty?
She
About
keeps
15 and a half
smiling
hours.
at him. It's really
Okay.
creepy.
And then you were hopefully
Oh my
supposed to get
God.
off at about what time?
Midnight.
So at 11:30, where do you know approximately where you were in Deerfield Township when you hear about this like dispatch of a disorderly person?
Yeah, we were finishing up a call. It was probably around 22, State Route 22 and Landon Drive.
How far is it? Because I believe the dispatch was 25539 Old Farm Drive. Was that nearby, or was that quite a distance?
Quite a distance away.
Okay. Were you there with any other deputies?
Yeah, Reed Eastham was on that call too.
So you were the dispatch came through. It was not for you to go to that call.
No.
Okay. But you heard it. Did you hear who did respond to that dispatch to Old Farm Drive?
Yeah, they dispatched 2 units. They dispatched the supervisor, Sergeant Simpson, and they dispatched another deputy who was coming in on midnights. So they dispatched him a little early compared to when his shift starts at midnight. So they dispatched 2 originally.
And with 2 people responding to that call, would that have been something normally that you would have automatically backed them up on?
No, not if they already have 2 responding, not necessarily, no.
On this evening, though, did you wind up backing up Sergeant Simpson?
Yes.
Can you just explain to the jury kind of how that progressed? What did you hear that led you to start heading that way?
So I didn't hear what the call type was originally, but I heard that there's 2 deputies dispatched to it. And he had originally asked for a second unit, and he had a second unit coming. But I kind of knew maybe the distance was far away. But when I heard his voice inflection, because when you work with these people, you kind of understand their voice on the radio. So you kind of understand when maybe they're in some type of dangerous situation or a different type of situation. So I kind of heard his voice inflection ask for to start another unit. So that's when I kind of keyed in and realized I needed to start that way because something wasn't good.
And when you started that way, did you go emergency lights and sirens, or were you just traveling over to that direction?
It was emergency lights and sirens to get there.
And why would you have stepped it up like that, or like gone emergency or lights and sirens to back up Sergeant Simpson?
Because as we're traveling there, you kind of heard the radio traffic of a taser being involved on a taser point, and then as is going, you hear a taser deployed, and then you hear one resisting. So that's the reason for it.
I just needs to grow a beard and he'll become a man.
When an officer is alone in that kind of situation, can things go very badly?
Yes, very, very, very badly.
Do you recall approximately how long it took you going lights and sirens to get to Sergeant Simpson's location?
Hey, Scott.
I mean, due to the nature of the situation, knowing that there's an officer there with one resisting or one not complying, it felt like 30 minutes, but it probably took 5 minutes maybe. I mean, I was going as fast as I could,
Hey,
as safe as I
Justin.
could.
Was any other deputies following you or going with you to that location?
Yeah, Deputy Reed Eastham was behind me, lights and sirens as well.
And en route to that call to back up Sergeant Simpson, at any time did you hear whether or not it went from resisting to actually like actively fighting?
Yeah, I mean, I remember. Yes, I feel like something on the radio was I got one actively fighting, or yeah.
Now, upon arrival to this scene, what do you first observe?
I observed Sergeant Simpson standing over top of the individual, and the individual was laying on the ground on his back.
And was Sergeant Simpson, did he have anything in his hands, or was he having any kind of like defensive weapon in his hand?
I believe he had his baton or his ass.
Okay. What did you do when you came upon that scene?
When I first got there, I wanted to get the scene secure as quick as possible, so I immediately went hands-on with the individual that was on the ground.
And when you say you went hands-on, what does that mean?
I got on top of him in order to control him and detain him.
Were you giving him any orders when you go over to Sergeant Simpson?
Yeah, when I get on top of him to control him, yeah, we're giving him orders to roll over and put his hands behind his back.
Would he have been able to comply if you're on top of him?
He would be. I mean, yes.
Would he have been able to roll over with you on top of him like that?
Yeah, I would have. If he would have, I would have let him roll over. Yes.
Okay. Then let me ask you this:
okay.
Did he, in fact, comply when you were asking him to roll over onto his stomach?
No, we had to physically roll him.
Are you kidding me, sir? You're telling me if this guy's on top of you, you're going to be able to roll over if you decide to? Oh, he'll let you roll over. Really? I mean, they act like he wasn't complying and he wasn't. But at the same time, when they're in these scuffles, do they really give the person a big chance before they just keep escalating things?
Over onto his stomach.
What about his hands? Did he immediately put his hands behind his back on his own?
No, he didn't.
Where were his hands when he was rolled over onto his stomach?
They were underneath of him.
Is that a
Yeah.
dangerous situation for officers? And if so, why?
Yeah, I mean, hands are extremely. You need to see hands at all times because that's very dangerous. They could have, I don't know, a weapon or a knife or anything.
And at this time, when you first approached that person that was on the ground, did you know whether or not that he'd been patted down and been searched and did or did not have any weapons?
I had no clue at that point.
So what did you have to do in order to be able to cuff that person?
We had to just physically roll him over and then physically put his hands behind his back to cuff him and detain him.
All right. Now, he was able to be cuffed.
He was, yes.
Once he is able to be cuffed, let me ask you, did you search him?
Yes.
And do you recall if you yourself found anything on this person?
Yes. When I searched his pockets, I saw a clip on his pocket. I thought it was a knife, but when I pulled it out, somebody had said firearm, and ended up being a firearm I was holding. I was kind of tunnel vision at that point to get to search him, but
So you found the firearm
I
on
did,
him?
yes.
And let me ask you, the whole location where you found the firearm, would that have been in the general location where that person's hands had just been underneath their body?
It was in his pocket, so yes.
Do you see that person in the courtroom today before we go any farther?
I do,
And
yes.
can you point him out to
I mean, yes, that is very dangerous for an officer to be trying to arrest somebody who has access to a gun. Absolutely. In this case, though, Brandon could have probably maybe reached it or could have tried to, but he didn't. So they're kind of just showing that he wasn't escalating things himself. At least that's how I see it. I'm just not impressed with the police work here.
driveways wearing in court today?
He's wearing a dark blue collared shirt and defensive.
Thank you for the record indicating the defendant, Your Honor.
Noted.
Deputy McClellan, first of all, when you're going lights and sirens to this location, would your cruiser cam have been running?
Yes.
And did it continue to run during this encounter with the defendant?
Yes.
And have you reviewed your cruiser cam?
Yes.
And I'm going to play the first 14 minutes, but is that the copy that we have, is that a fair and accurate copy of your cruiser cam as you reviewed it?
Yes.
Your Honor, at this point, I'd like to play the first 14 minutes of Deputy McClellan's cruiser cam. It's going to be exhibit number 5.
You may proceed.
Thank you.
Ladies and gentlemen, just so you understand, these recordings are going to be admitted into evidence. And if they are admitted into evidence, they're going to be available to you in the jury room. You're going to have a laptop without internet access, and you'll be able to play those in the jury room. So if you're taking notes and you want to make notes about time indexes, you can go back and look at those. Also, the entirety of the video is going to be admitted, even though you are not going to see all of it from the courtroom. So the attorneys, Mr. Riefers, they may play parts of it, but you're going to have the entire video. If you want to stop it, frame by frame, whatever you want to do with it is on you. But you will have that exhibit back with you in the jury room. All right, go ahead.
Your Honor, if I may object or play the video.
Hold on. Did you pause it?
Yes.
Approach.
Uh-oh.
What was the exhibit number again?
5.
Hey, he didn't come to a full and complete stop. Really? Couldn't have started this any further back? Why don't you show him picking up his Dunkin' Donuts order 10 minutes before this, too? Oh, good. Now we're just looking at the woes of Ohio traffic. Okay. Safety first. Gotta use your turn signal. There we go. Oh, no. They're just gonna run the red light. Okay. Oh, humming danger music to himself. Yeah, sure. Just go ahead and take your half out of the middle. Oh, I didn't even have enough time to grab his pursuit mixtape and put it in the deck.
2 Charles 49, route to 80. 2 Charles 14, clear now ER, 104340.
Serious Jesus, dude. Well, he's Popo, David, but yeah. Yeah, go faster. Oh, good. Go through a neighborhood at this speed. What could go wrong? Jesus, little Timmy comes running in the street going after a ball.
Good God. What is your fucking PC for stop, bro?
He's still on the PC.
Come here, there, Gus.
I'm complying. I'm complying. You fucking tasered me for no reason, partner.
And you come at me like that.
Hey, partner, I didn't come at you. Hey, what's your PT for fucking stop? What's your fucking PT for stop? Huh? What's your PT for stop, Mo? Huh? What's your fucking PT for stop? Huh? No? No PT for stop.
Yeah.
That's exactly right. Hey, why don't you go ahead and pull out a fucking credentials?
I understand that some people will ask a question, they get an answer, and then they keep going and they keep being hostile on and on and on. But the officer could have at least answered that and at least try some kind of de-escalation. He may have been drunk. A little drunk. Maybe. Or maybe he was just in a bad mood because he didn't get laid. And I know, yeah, they had PC for the stop. I'm not saying they don't, but you still should articulate it.
You fucking tase me, bro?
Watch out, you got a problem on them, fellas. Yeah, roll on the other side.
Yeah, because I'm a fucking commissioned officer. You gonna fucking tase me?
Not anymore, you're not.
That's on your butt. Partner?
Hey, you're hot.
You tase this
You
number?
talk with the gun and you fight it.
No. You got tased for no reason. Where you a cop at? I'm a retired state trooper out of fucking Texas.
Okay.
You get tased for no fucking reason? I'm actually a fucking certified training officer in fucking taser, dickhead.
Oh, I'm a
Tase me for no reason? Tase me.
I don't know why. I just love that line. I got to hear that again.
Okay.
You get tased for no fucking reason? I'm actually a fucking certified training officer in fucking taser, dickhead.
Oh, I'm a
Tase me for no reason? Tase me.
I'm a certified taser officer, dickhead. Oh yeah, they could have found him guilty based on the testimony of the people he was with who claimed they saw him drunk and all those things. I'm a certified Nissan mechanic.
Yeah.
Hey, you need a medical data plan.
Yeah, I hate to watch it all. It's going on. You came out and I put some back and talked to David. Yeah, so don't mind this corner up here. Turn around, do a traffic. We take up like that hill. Come here, send your brake on, send it up the park. And I go up to start talking to him. This is the windshield. And I just had to go by and stop and give a hard time. Go ahead and step out of the car. Just step out of the car and walk away. I can't get here fast enough, dude. Like that, everything is going down. They got to take it. Came out and get the side of the car. And then, somebody tell him we're okay. And then, somebody tell him we're okay.
What? Oops. All right, guys.
Did anybody else use any? No. Hey, yeah, general. We did have a loaded firearm. Yeah. One of those guys on the. No, one of you guys got it. Oh, yeah. I don't know what happened.
How many cops does it take to arrest one guy for OUI? One to do the grunt work and 7 to stand around and look bored.
You sort of tell him.
You ran that yet?
I can find the story.
Oh, nothing to do with evidence. I just don't like talking to people, to be honest. Unless I'm a personal friend.
Like you. That's my personal friend. Like you.
Just one of those that doesn't walk back and from acting. It's on me somewhere. It's been clean forever.
I'd laugh so hard if that gun went off and the shot just hit the camera.
I wonder if that's going to be it. Yeah, that looks like it's it. Considering that's where the metal is at. I'm not sure it's probably not this.
Who was that on? Did you find the gun or was it? I found the gun. Where was that on? So when you rolled him to the opposite side,
So it was on his
right side.
right side.
Yeah. With the knife.
I saw the knife set up when I talked to him over there. Losing my voice and screaming at him.
Yeah. I'm gonna need
I wish they would have started somebody else over here when I initially got dispatched on this.
Yeah, you were
I was 741 and 63. I was hoping dispatch would be like, hey, smart mate, you know, because I saw everybody else was busy, but I'm
I
like,
thought you were attached to it.
I'm sure Mason was for the car.
Yeah.
And then, you know, unfortunately, until all hell breaks loose, when
I just stopped and just talking and see what's going on. And he punched the windshield.
What's insane is the
did you punch his windshield?
Yeah.
Oh, okay.
He said the car punched.
what's insane is the call fight is nowhere.
Oh,
near
he just said he punched his windshield.
Smelling.
How embarrassing if you get tired.
How embarrassing.
Really, give all the team file.
Deputy McCollum, the items that were put on top of that car of your cruiser, was that the firearm that you recovered from the defendant?
Yes, it was.
All right, and it looked like you put that in a plastic like evidence bag as well as other items. What were the other items? Do you recall?
Yeah, it was the magazine and the shell or bullet that was taken out of the chamber.
Okay, so it was a loaded firearm and one was in the chamber?
Yes.
Okay. They show you what's been marked State's Exhibits 4 and 19. Do you have scissors? I'm sorry. You don't have to necessarily open 19 if you don't want to, but if you can open 4, tell me if you recognize it. And actually, if you also recognize that, we'll talk about it.
You do that near the mic. Any closer, buddy? Let's point it at the jury.
Yeah.
Does that appear to be the same firearm that you recovered from the defendant that day?
Yeah.
And can I just ask you, how would you know that was that from the one you recovered versus one that was found somewhere?
It had the clip on it, so he could clip it on the inside of his
Go ahead and
pocket.
point it at
Okay,
your
so
dick, sir.
It was clipped to the inside of his pocket?
Yes.
Okay. And is there any, and then did you tag and bag the evidence that day, or did another deputy?
Another deputy did.
Was that Deputy Peters?
Yes.
Was that who we saw towards the end there in that, in your cruiser cam?
Yes.
And just for the record too, you were looking, like you both were looking at the firearm a lot. What were you looking for?
I tried to find a serial number so we can run it through leads to make sure it wasn't stolen.
Okay.
Don't point
Did you in
it
fact do
there.
that for the record?
Yeah, Peters did. I did not.
And that would have been the firearm you handed to the Mason officer who then I think was the first one to put it on your cruiser.
Yes.
I know it's not a SIG P320, but still, buddy, come on.
All right. And the safety for 19, I'm sorry. Is that the magazine that would have come from that weapon in number 4?
Yes.
Right. And the actual bullets or case ammunition for it?
Yes.
And is that marked on there as to what type of firearm was that?
It's a 380.
Is it Cal-Tech?
Yes. We can pull it out again, or
You know how to just might double check the.
Pull it out again? Whoa, sir.
And does that
That's
weapon
prosecutor, buddy.
basically the same condition as the last time you saw it?
yes,
Same thing with the ammunition.
yes.
All right, that's all I have.
So Riefers, you may inquire.
Thank you, Your Honor. Thank you, Deputy Collins, for being here. Just want to go through a few questions. First, you're not the arresting officer, correct?
No.
Your role that night was just secondary support.
As a backup deputy, yes.
You did not witness the initial contact between me and Deputy Simpson, is that correct?
Correct.
You did not witness the alleged resisting movement
What resisting movement?
when Deputy Simpson called on the radio, he's got one resisting.
Oh, correct. I did not witness that. No.
And then, did you write
Should have
a
said good
report
question.
based on all this information and all the evidence that you gathered?
I did not write a report. No.
Does your policy require you to write a report?
No, the primary deputy needs to.
Okay. And then, did you do an inventory of the vehicle?
I did not know.
Who did the inventory of the vehicle?
Probably Deputy Peters. There was a lot of deputies and officers on scene, but I didn't conduct the inventory.
You didn't do the inventory of the vehicle? Okay. Did you take any photographs of the vehicle?
I did not know. Other
No.
deputies did.
I'm sorry,
Other deputies did. I did not know.
you don't know who though?
Probably Deputy Peters.
Peters. Then, we did have, and this video is 14 minutes, correct?
Correct.
When you upload your videos through Axon, do you have any control in that, or does it just go to like a central server?
I don't work for Axon. I just record and turn it off when the incident's over.
Okay.
So it probably goes to a central server.
So this 14-minute clip isn't the entire video, correct?
I couldn't answer that.
What I'd gotten was like an hour and a little over an hour long video. I didn't get this 14-minute clip. The initial clip I got was like 2 minutes. So I'm just trying to figure, did you make those clips, or how do those?
I did not make those clips. No, it's all sent to a central server, and then we have a gentleman that works that portion.
And that'd be Paul Sarver.
Sure. Yeah.
He's the one that maintains the custodian. He was the one that testified earlier on the way.
Okay.
All right. And then did you testify earlier? Because we did do a deposition because you weren't going to be able to make it initially, correct?
That's correct. Yeah.
And in that deposition, did you testify that when you were on scene and made contact with me, you noticed my eyes were not bloodshot, they were not glossy, and they did not have a slurred speech, and that I was compliant with you?
I didn't say you were complying with me, but I did say the other ones, yes.
You didn't say that I was compliant with you?
No, I said that you said you were complying, which you said in the video I'm complying, but your actions and
Thank you.
words were different.
And then from the time you arrived on scene and went hands-on with me to the time that I was rolled over, do you remember approximately how long it was? 5 to 7 seconds?
Yeah, it's pretty quick.
And I noticed that there was 2 deputies that had come up. One came on where I'm sitting down like this, one came on the right side, one came on the left side. And so that 5 to 7 seconds that you guys were saying I was resisting, could it not have been one deputy's pulling me one way, one's pulling me another way?
No, that didn't happen.
Hope that didn't happen.
No.
And then when you rolled me over, you said my arms were underneath myself.
Correct.
But the video shows my arms were still up. You guys grabbed them and pulled them behind me.
I didn't see that in the video, but
You didn't see that in the video?
No.
Okay. And then when did your department switch and go to body cameras?
since that incident, we've switched.
Was it because of the incident?
No, absolutely not.
And then while you were up the vehicle, you didn't do the inventory, go through the car, or any of that stuff in the vehicle?
I assisted. I was going to look to help out, but I just kept everything where everything was.
Okay.
So I didn't know.
But you looked in the vehicle?
Briefly.
Okay, when you first looked in the vehicle, did you see a bottle of Fireball sitting on the driver's seat?
I don't recall.
And did you notice if there was like any smudges or anything on the windshield?
I don't recall.
Okay. And then were you aware that Deputy Simpson stated in there on the video, stated that I punched the windshield, but then later stated yesterday that I made a punching motion?
What was the question?
Were you aware that Deputy Simpson stated on this video that I punched the windshield? But then when he testified yesterday, he was stating I made a punching motion.
I would
punch the windshield.
Yeah, I wouldn't have no clue what he testified to.
And
Good to get it out there. Remind the jury of that.
so when you get your videos, how do you guys upload them or download through the system?
I don't work that portion, but I plug my body cam into body cam now was different from the body mic that we had. So, but body cam, we plug it in and it uploads to the server.
Okay. The old system,
The old system probably handled this. It just uploaded to the server itself.
it just goes from your car. You don't have to go in the office and upload or anything.
I do not know.
And then the new system now into the body camera. So when that came into place, did they issue a new policy for the body cameras?
There's a body camera policy, yes.
Was there an old policy prior to that for audio and video equipment?
Yeah, there's a policy for that.
Okay. Do you happen to have a copy of that? I'd request one. I don't have it.
I don't have a copy of it right now.
And then,
It's a copy of the officer's OnlyFans.
and do you have, are you intoxilizer certified?
No, I'm not.
Okay. And you said you've been with the department roughly 2 years?
Roughly 2 years.
Okay. And how many OVI, DWI arrests have you made?
Maybe 4 or 5.
And have you ever refused anybody to a chemical test?
In those,
Only corn.
no, I did not. It just depends on their actions. But
Okay. No further questions, Your Honor.
Anything else for this witness?
Just one. Deputy McClellan, are you required to be certified on the intoxilizer in order to be a Warren County Sheriff's Deputy?
no,
And why not?
because we're trained in OVI detection with their actions and eyes, verbal, driving. We don't have to be trained in breathalyzer.
And in this particular case, you did not see the defendant driving,
I did not know.
and you had a brief interaction with him on the side of the road there.
Yes.
Okay. Did you have any further interaction with him after that?
I transported him to the jail and then was in the jail with him when he was getting booked in. But
Other than that, nothing more than that. Okay. Thank you. That's all I know.
Anything else for this witness?
Yes, Your Honor. She asked about does the department policy require you to collect all exculpatory evidence?
what do you mean by that?
Meaning in an OVI case like this, any evidence such as blood, breath, urine, something to prove intoxication or not?
Yeah, if they're complying, if they're being cooperative and complying, we will, yes. But if they're a threat, then if they're not cooperating, then we're not going to risk further harm from somebody to get one of those things.
I can understand that it'll be each circumstance, but your policy clearly states you must collect all exculpatory evidence.
Circumstances, yes.
Okay.
If they're complying.
And if there's ever a situation where the test isn't offered and a defendant's requesting, does your policy require you have a duty to intervene for another deputy to step in and somebody to run the test?
If they're complying and cooperative, if we need to get that, then yes.
Thank you. No further questions, Your Honor.
You deputy can step down. Next witness?
Deputy Eastham.
Swear to affirm the testimony in this proceeding to be the truth, the whole truth, and nothing but the truth. So, okay.
Good morning, Deputy. Good morning. Can you please state your name and spell your first and last name for the court recorder?
My name is Deputy Reed Eastham, R-E-I-D. His last name is Eastham, E-A-S-T-H-A-M.
And I'm just going to ask
When
you.
did you
sometimes
graduate
for
middle
some reason,
school,
this
sir?
in here kind of soaks up your voices, so if you can just keep your voice up so they can hear you all the way back there. Can you please, for the record, tell us who you're employed by
I am employed by the Warren County Sheriff's Office.
and how long have you been there?
I've been with Warren County for, probably around 3 years now.
Did you have any prior police experience?
I worked in corrections with the Claremont County Sheriff's Office for about 2.5 years prior to coming over to Warren County, and then went to Warren County jail for a year before I came out to the road.
How is this
And
kid
has
12
he
and
been
also
primarily road
balding at
patrol
the same
3 years
time?
You've been with the sheriff's office?
At this point in time, it's about 50-50.
Oh, 50-50. So 50-50 with the being in the jail and road?
Correct.
Okay. Now I'm going to take you back to Saturday, November 9th of 2024, about 11:30 or so in the evening, would you have been on duty as a Warren County Sheriff's Deputy on that date and time?
I would.
Would you have been in a similar uniform of the day in a marked cruiser?
Yes.
What shift would you have been working that day?
At that point in time, I was on an evening shift, which is 4 p.m. to midnight, but I was staying over until 4 a.m. on an overtime shift.
All right. Now, at around 4:30, 4:39, do you hear a dispatch of a disorderly intoxicated male to that 5539 Old Farm Drive?
It was sometime in that evening, but yes, a dispatch did come out for a call of that nature.
And at the time you hear that, were you able to respond to that call?
No, I was not. I was on scene of another incident.
And was that with Deputy McClellan?
It was.
They
Do
only
you
hired
recall
this dude to
approximately
bring the
how
average
far away
department
you
weight
would
down
have
to
been
regulatory
from that
limits.
call to 5539 Old Farm Drive?
Mileage-wise, no. I know typically it would probably have been a 10-minute drive, just, with traffic and whatnot going on.
All right. And on that particular day, since you and Deputy McClellan were already busy, did you know who did respond to that call?
Sergeant Simpson was responding. I knew he was a lot closer than anybody else, and I believe Deputy Peters was also responding, but he was north of 63.
And is that far from where we are here in Deerfield Township?
From down with the incident location is that, yes, it is quite a ways.
Let me ask you then, subsequent to hearing that initial dispatch, do you hear anything else from Sergeant Simpson that was concerning to you?
In regard to call for service coming out, no. I was on scene dealing with my incident at that time.
And then after that, when you finished that incident and you cleared the scene, did you eventually go to 5539 Old Farm Drive?
I did.
And why would you do that?
So as I was clearing the scene, I was about to make a left-hand turn onto westbound 22. Sergeant Simpson rated out that he had one resisting.
Now, when you hear that, at this point, do you know if the other deputy had made it from 63 all the way over to Sergeant Simpson's location?
I did not.
So as far as you knew, did you believe that Sergeant Simpson was alone at this time?
I did.
And just so the jury understands too, can things, when somebody's resisting an officer who's by himself, can that go from bad to worse quickly?
In the matter of an incident, split seconds.
And based on you hearing Sergeant Simpson say he had one resisting, what was your response to that?
I immediately turned on my lights and sirens and started driving as quickly as I could while being safe to get there.
And were you following Deputy McClellan?
I was.
En route to that, do you hear anything further from Sergeant Simpson that was concerning?
We heard he had one at taser point and he was waiting for an additional unit. A couple minutes later, we heard taser deployed. Maybe 15 to 20 seconds after that, give or take some, we heard that we need to step it up, that he was actively fighting one.
All right. And then upon arrival, would you have pulled in right behind Deputy McClellan's cruiser?
Yes.
And we did see people responding. We saw Deputy McClellan respond to where the situation was. When you arrived, what do you observe?
I observed the defendant, Mr. Riefers, was on his back, and Sergeant Simpson was over top of him, attempting to kind of keep him on the ground with his expandable baton up above his head.
Whoa.
Could you hear Sergeant Simpson giving that person any orders?
Don't remember if I heard him giving orders or not. I know that when I got out of the car, I was.
I'm sorry, when you got out of the car,
I began giving orders for him to roll into his stomach.
All right, so do you run over to that location where Sergeant Simpson was?
I do.
And what orders were you giving?
Initially, I was ordering him to get onto his stomach. We had to forcefully roll him onto his stomach. He was ignoring commands to get onto his stomach. Once he was on his stomach, the orders changed from get on your stomach to give us your hands.
When you first ran over there and told that person, get on your stomach, did they immediately roll over and get on their stomach?
No, we had to forcefully roll him onto his stomach.
Man.
And when you rolled them onto their stomach, where would their hand position have been at that point?
Their hands were tucked underneath their body.
Is that concerning to you?
It is.
And why?
Well, people normally carry weapons in the front portion of their waistband. If they don't, it's going to be on their hip. But where his hands were at, it was underneath his stomach, kind of in his abdomen area, which conceals handguns, knives, a numerous amount of weapons to be concealed there.
And at this point, had you been told whether or not he had been searched and
undescended
did or did not have
testicle.
weapons?
We had not.
Okay. Now, when you were ordering him to put his hands behind his back or show you his hands, did that person immediately pull their hands out from underneath them and put their hands behind their back?
No, ma'am. He was given several sets of commands to do that, at which one time we had to forcefully pull his hand and place them behind his back.
Were you told that there were any weapons recovered from that person?
After the fact, yes.
And what type of weapon were you told that he had?
I removed personally a pocket knife from his pockets. I don't remember which pocket, but there was also a .380 caliber handgun, which was loaded in his waistband or front pocket.
All right, and so
I volunteered to search his
You've
pockets
reviewed your
4
cruiser?
times.
I have.
when we saw Deputy McClellan running, were you the second person also running
I was.
right by him?
Yes.
That person was able to be cuffed?
Yes, ma'am.
Do you see that person in the courtroom today?
I do. He's behind you at the defendant's table in a blue shirt.
For the record indicating the defendant, Your Honor.
Noted.
Did you have an opportunity after that the weapon was recovered to look at that weapon?
I did. It wasn't for a very long amount of time, but I did observe the weapon, yes.
Let me ask it this way. Do you remember what caliber it was?
I believe the one located in his waistband was a .380.
And do you know if it was loaded or not, if you know?
I believe it was loaded, yes, to my knowledge.
Were you one of the ones when when the defendant was cuffed, where was he taken to?
He was taken to the rear of Deputy Peters' cruiser.
And were you one of the ones assisting him to Deputy Peters' cruiser?
I was. It was myself and Deputy Peters.
And did he willingly walk over to Deputy Peters' cruiser, and get into the rear?
Okay. At first he did. About halfway there, he completely picked up his leg and we had to carry him to the car at that point in time.
Being that close to the defendant, did you notice anything about him that, I guess just anything about him, period, that you would have want to notate, like in a report or anything?
I noticed that he was intoxicated, or at least was giving signs that he was under the influence of some sort of alcoholic beverage.
And what led you to believe that that was true?
Slurred speech, the odor of an alcoholic beverage, which I'm fairly familiar with from working in correctional facilities and on the road.
And was that odor of alcohol, was it a subtle odor, strong odor, or something else?
It was a strong odor.
And it was coming, just for the record, from the defendant?
Correct.
Okay. Did you have any interaction with the defendant in the rear of Deputy Peters' cruiser?
In
I
the
did.
rear?
I photographed the taser probe impact points on his person. I also checked his handcuffs, and then Sergeant now Lieutenant Kaido and we adjusted them to make them more comfortable and not as tight, as well as I stood by while the medics evaluated him prior to being transported to the jail.
And in the rear of Deputy Peters' cruiser, when you were helping to adjust his cuffs, did you notice any odor of alcohol in the cruiser itself?
I did.
Was it, again, a subtle, strong, or an odor of
It
alcohol?
was a strong odor of alcohol.
All right, that's all I have. Thank you.
Mr. Riefers, you may inquire.
Thank you, Your Honor. Thank you, Deputy Hill. And I'm sorry I missed. How long have you been with the department?
I've been with the Warren County Sheriff's Office since 2022.
22?
Yes, sir.
And you were the deputy that went and interviewed the witnesses then afterwards?
No.
And how do you spell your last name? I'm sorry.
Eastham, Eastham.
Yeah. Yeah.
So did you observe? You come up second, and you were there with McClellan.
Correct.
McClellan come up. So as you guys approached, one's on my right side, one's on my left side. Correct.
Yes.
And that took approximately 5 to 7 seconds to roll me over before you handcuffed me. That's what we were seeing on Deputy McClellan's video, the 14-minute clip.
I'm not sure which video you guys watched earlier. I wasn't in the room.
About how long did it take for you guys to go hands on and roll me over?
Well, once we went hands on,
Yeah.
it wasn't too long, maybe 10 seconds.
Okay. And is it standard practice to take the subject's boots off?
Don't remember boots being removed, but
Yeah, they took the boots off of me. I just wondered if that's standard practice why they did that.
Or he just had a foot fetish.
Is that something you would normally do?
depends on the situation, I guess.
Okay. And then you mentioned as I was walking to the car, I started limping. Did you notice which leg was limping?
Sir, you didn't limp. You picked both of your feet up. That's
When they were walking me over?
Yes, sir.
We just saw in the video that I walked over and then limped at the end
Objection,
there.
Your Honor.
The objection is sustained. Jury, the video speaks for itself. Go ahead, Ms. Riefers.
Thank you, Your Honor. Did you photograph? I know you said you photographed taser probe impacts, correct?
Yes.
Which location did you photograph?
Photographed your person, your body.
All taser probe impacts?
The ones I could find on scene, yes.
Okay. Which was just the set in the chest?
I can't remember exactly which sets. I know I checked. I didn't completely disrobe you on scene. So what was visible, yes.
Gotcha. Did you take a picture of the impact probes on the arm?
It's possible.
Yeah, we didn't have any photos. I was wondering if you were the one that had taken all the photos of that.
Deputy McClellan took photos of injuries at the jail. I also took photos of you on scene. I don't remember exactly every photo that I took of you that night.
Okay. Did you do like photos of the vehicle?
I assisted in taking photos of the vehicle, yes.
Did you take all the photos in the vehicle?
No.
Do you know who did?
No.
Do you know if any of the items in the vehicle were moved prior to photos being taken?
Not to my knowledge. I don't know. I didn't take all the pictures.
Gotcha. Okay. So would it surprise you on Deputy Carter's video at 37 minutes and 42 seconds, she's back in the car looking for insurance. Were you there present when she was there?
I could have been on scene, but
Okay. And then did you hear her say, asking if the photos had been taken? And they said no. And then she stated, I'll put this back so I don't ruin your photos.
I don't remember.
Do you remember seeing a Fireball bottle sitting on the driver's seat?
Remember those alcoholic beverages located in the vehicle. I don't remember the brand or where they were located.
And then, let's see. And you're intoxicated certified?
No, I'm not.
And how many DWI arrests have you?
My time as a deputy sheriff, I believe I've had 3.
3. Okay. And of those 3, did you refuse anybody a chemical test?
They refused chemical tests.
They did. The subjects did?
Correct.
Okay. But you offered the test?
Yes,
Okay. When those subjects refused, did you have them sign a refusal form?
if they were willing.
Okay. No further questions, Your Honor.
Anything else for this witness?
Just a question, does it based on circumstances and how the person is acting in order whether or not you
How old are
offer
you?
certain types of tests or not? Or,
Correct.
Okay, thank you, that's all I had.
Anything else for this witness?
Yes, Your Honor. Deputy Hales, is the department's policy that you're required to collect all exculpatory evidence in any investigation?
I'm sorry?
Is it your department's policy that you must collect all exculpatory evidence in an investigation?
I'm not sure what you mean by exculpatory, sir.
Chemical test, anything that could dissipate, anything that could prove innocent or guilt?
If it is safe to do so, yes.
Okay.
And also, my name is Deputy Eastham, not Deputy Hale.
I'm sorry?
My name is not Deputy Hale, it's Deputy
I'm
Eastham.
sorry. Okay. I have no further questions, Your Honor. Thank you.
Thank you, Deputy. Step down. Next witness?
Whatever,
Deputy
Junior.
Peters.
Good point. Yeah, it is just evidence you're supposed to collect, not it. Don't know if it's exculpatory at that point. Good Lord, another one. This guy just looks like he got out of the freaking locker at high school.
I showed you yesterday.
Come on, ma'am. Oh my God.
Good morning.
Good morning.
Please state your name for the record and spell out your first name, why not?
Sure. Nicholas Edward Peters,
The average age of this
Nicholas.
police force?
And for the record, what is your occupation?
I'm a deputy sheriff with Warren County.
And Deputy Peters, how long have you been with the sheriff's office?
Approximately 1 year and we'll call it 9 months.
Okay. And did you have any prior police experience before the sheriff's office?
Yes, I have worked for prior agencies.
And just like
Sure.
most recently, who was the most recent one before the sheriff's office?
Sure. Miami Township, Montgomery County.
How long
Boy
were you there?
Scouts?
Just under 2 years.
And when you were working like in Montgomery County or here in Warren County, was that all primarily road patrol?
Yes.
So people call 911 or call for police or help and you respond or you see traffic offenses, that sort of thing?
Yes.
Okay. Deputy, I'm going to take you back to Saturday, November 9th of 2024, around 11:30 or so in the evening. Would you have been on duty yet on that date and time as a Warren County Sheriff's Deputy?
Yes. My official shift did not start until midnight. However, I was signed on and ready to take calls at 11:30 p.m.
And that evening, would you have been a similar uniform of the
Can
day
you
in the Mark
shave?
Cruiser as well?
Yes.
All right, so you're coming into work.
Yes.
When you are coming into work, do you hear anything on dispatch?
Yes. Dispatch radios me on my in-car radio and asked me to respond to, I believe it initially came out as a disorderly subject. Can't remember the exact street. And, they asked me, are you going to respond? And I answered affirmative.
Now, was that location in Deerfield Township?
Yes, it was.
And if I said 5539 Old Farm Drive, would that sound right to you?
Yes.
Now, from where were you approximately when you heard that dispatch?
Approximately, I was at 63 and 741.
And is that a good distance from Old Farm Drive?
Yes.
So when you hear that, and for the record, is Old Farm Drive, that location that you were dispatched to or put yourself on, is that in Warren County, Ohio?
Yes, it is.
And when you are going there, are you just traveling there like at a normal speed or are you going like lights and sirens?
Initially, I responded routine, which is just obeying traffic laws. However, I heard Sergeant Simpson arrive on scene first, and he radioed shortly after that he was fighting someone. At that point, I activated my overhead lights and sirens and proceeded emergency to the call.
And when you arrived, were other deputies already on scene?
Yes, multiple deputies.
Because it took you quite a while to get
It did,
there.
yes, it did.
All right. And was the person that Sergeant Simpson was fighting or having issues with, was that person already in custody by the time you arrived?
Yes, they were already in handcuffs.
But they had not been placed in any cruiser yet. Is that fair to say?
Yes.
Because that person wound up in whose cruiser?
My cruiser.
In the rear seat?
Yes,
Do you see that person in the courtroom today who was put in the rear seat of your cruiser?
I do.
Can you point him out, describe what he's wearing today? Sure.
He's sitting right over there wearing a blue shirt, has a beard and glasses.
Thank you. Indicating the defendant, Your Honor.
Noted.
When you arrived then, since he was already handcuffed and in custody, what was your duty at that point?
So the deputies that were currently with him as he was handcuffed, I walked over and escorted the defendant over to my cruiser and placed him in the back of my cruiser.
And did he willingly walk over there or did you have to escort him in another way?
We had to escort him. He wasn't quite pulling away, but he was being verbally combative with us, wanted to speak with the supervisor, was upset that force had been used against him, and had to be escorted over to the cruiser.
Did you actually have a hold of him, escorting him over?
I did, yes.
Did you have to carry him at any point?
Yeah, it wasn't a drag, but I definitely assisted with some of his weight by walking him over to my car.
All right. So then he's put in the rear of your cruiser. Do you have any contact with him initially, or what do you do next?
What I do next is he's in the back of my car, and at that point, I believe Sergeant Kaido comes over and starts talking to him about what had happened. He was doing at that point a use of force investigation.
Because the taser had been deployed.
Yes.
Now, are you assigned a duty at that scene?
Not immediately, no. Typically with something like this, because the scene is still dynamic, if you will, you find the need, you find what needs to be done. And in this situation, with him being arrested and his vehicle still being on scene, it needed to be inventoried and towed.
All right. Did that become, let me put this way, did that become your job?
Yes, it did. I volunteered essentially.
And so you then kind of became the collection of all property.
Yes.
Okay. Now, in this particular case, were you shown a loaded firearm on the hood of Deputy McClellan's cruiser?
Yes. Yeah. Deputy McClellan had retrieved a firearm from the defendant's person once he was handcuffed, and that was placed on, I believe, the hood of his cruiser.
All right. And did you in fact collect it?
Yes, I did. I collected it.
And just so the jury understands, when you collect evidence, you're at a scene. Do you stand there and then package it, put it in all these nice paper bags, and mark them at the scene, or do you do that somewhere else?
I do that somewhere else. Initially, when it comes to, in this case, collecting a firearm, especially one that didn't need to be tested for DNA, I have plastic evidence bags that I place that into. And then from there, I place that evidence in a secure location in my cruiser. Typically, my spot in my cruiser is the front seat passenger floorboard. That's typically my reserve spot for evidence that I'm going to take back to then process and put into evidence at the Deerfield Township Post.
And I'm assuming like regular citizens that just can't come up and open your car door and say, oh, hey, look what I found.
No, absolutely not. My cruiser remains locked.
All right, thank you. I'm going to show you, if I can right now, State's Exhibits 4 and 19. Tell me if you recognize those two items.
Yes, I recognize this. This was a magazine to one of the firearms. And
Would that be to, do you know which one, if that was a 380?
yes, this is to the, this magazine is to the 380.
What exhibit are you talking about, Deputy?
The exhibit,
It's on the other side.
oh, sorry. This would be State's Exhibit 19.
All right, and how do you know that's the same ammunition that we saw on Deputy McClellan's cruiser?
So I walked up and also looked at the firearm as well. The magazine had, I believe, had already been taken out. I remember looking at it just because it was a smaller size firearm. I looked at the ammunition, and then I was the one who collected that, put it into a plastic bag to later be put into evidence.
And then do you mark that bag and once you do eventually put it into evidence?
Yes. So when it comes to placing something into evidence like this, you put it into we have these style evidence bags. The top is sealed with a tamper-proof seal, so that way if anybody tries to get into it, it's obvious that somebody had gotten inside it. And then the way our evidence systems work, when I enter that in, it prints off a barcode that shows what was entered in. I place that sticker barcode on this bag, and then from there, evidence is then placed into evidence lockers that are then shut, that cannot be opened unless you are one of the we'll call it one of the evidence control technicians. So if I needed to get that back out, I don't have the ability to do that. It would have to be somebody who has the keys to access the evidence.
Now on that, still on State's Exhibit 19, I know you printed out like the barcode and all that. Did you mark with your initials or anything else
Yes.
as well?
Apologies. Yes. And then again, on top of the tamper resistant seal up here, it is a policy to you put your initials. So again, that way, if anybody tries to take it open or rip it open, they're going to see that that your initials no longer match up. At that point, it would be you wouldn't be able to match up where I had written my initials, Nicholas Edward Peters. You could see that there would be a discrepancy.
And that's the large.
Yes, that's the large NEP. Yep.
And Deputy Peters, before you put that down, can you tell, has that been open since you first put it in this locker?
No, not as far as I can tell.
Okay, thank you. Then State's Exhibit 4, which is the bag. Can you tell me if you can open? First of all, that's not, I'm assuming, not in the same condition as the last time you saw it.
No, it is not.
Because it is open. Is that fair to say?
Yes.
All right. Can you look inside that? But did you mark that with your initials and also with the barcode? Not that like you did some way to
Yeah. So when it comes to firearms, like I said, unless it has to be tested for any type of like DNA evidence, the way we catalog that, or the way we are trained to put that into our evidence is, if it can be, the slide is locked to the rear just to show that it is unloaded, and then we have a red plastic tag, if you will, that is run through the magazine well, and then this tag, you kind of cinch it down so that way it can't come off. That way the weapon is left in a safe position, and then it is just placed directly into that cabinet. It wouldn't necessarily go into a plastic bag that looks like this.
All right, can you open that open bag and just confirm if that's the same 380 that you collected on November 9th?
Yes. Sorry, I want to make sure I don't muzzle anybody. And yes, this is the 380 that was collected that night.
And for the record, there's a property or receipt tag attached to that gun.
Yes, and then to catalog these as well. Something I forgot to mention, we do use these yellow tags that are just placed around some part of the firearm. And then again, if you notice here, again, another tag is printed out to signify what this is. So that way, when it's scanned, it comes back and it says, oh, hey, this is a, I believe a Kel-Tec 380 in our evidence system.
And that would have been the same Kel-Tec 380 you recovered from Deputy McClellan's cruiser hood.
Yes.
Thank you. Now, just for the record, can you just double check? It is not loaded in any fashion. Is that
no?
Right?
Nope.
All right, you can put that back in there. After putting these items, I believe, into the front passenger floorboard of your cruiser, what was the next thing you did at the scene? Do you recall?
Yes. At that point, the defendant's vehicle needed to be inventoried prior to it being towed, according to our department policy. I went over and started near the driver's side area. I opened the driver's side door. I shined my flashlight inside, and that's when I observed another firearm inside the vehicle. It was resting on the driver's side floorboard up against the center console area. So if you're sitting in a vehicle, it would be closest to your right foot.
And just so the jury understands too, why would a motor vehicle need to be inventoried before it's towed?
Sure. So the reason why we inventory a vehicle, especially if the defendant's going to be is being arrested, so it's to protect the defendant's property. We don't want somebody breaking into that vehicle. It's to protect us against claims that property could have been removed without permission, and then also it's to protect the person towing the vehicle, to make sure that there's no dangerous materials inside that could harm anybody with the towing company.
So I can't come back later and say my $10,000 and my motor vehicle is suddenly missing.
Yes.
All right. I'm going to show you now. Let's get my state's exhibits 8 through. Sorry.
Okay, Louise.
8 through 17, and then 21 through. Sorry about that. 25. I'll keep them separate. So 8 through 17, 21 through 25. These are all photographs. I just want to see if these are photographs you recognize or if you in fact took yourself.
Yes.
So if you want to start with E.
Go over here.
Yeah.
Okay.
Please.
Yes. Yes, states exhibits 8 through 17 are photographs that were taken by myself at the scene.
All right. And do those photographs appear to be a fair and accurate proportion or photo of what you actually saw that evening?
Yes.
All right. And then also, well, I'm going to take those from you.
Sure.
If you can also look at 21 through 25 while we're.
Sure. And then same for states exhibits 21 through 25. Those are photographs taken by myself on scene.
Okay. Again, for those as well, those fairly accurately depict what you observed that evening.
Yes.
And you can just set them on the edge there right now. I'm going to show you states exhibit 8 at this point. What is states exhibit? States exhibit 8, excuse me, up picture up.
So this would be the rear of the defendant's vehicle.
All right. And the driver's side, is that the driver's side or?
That'd be that's the driver's side door.
Thank you. That's open?
Yes.
And it's going to be real hard on these, but states exhibit 9. try to do my best to edit in the future. What's that? Why did you take that picture?
Sure. So this is the photo that I first took when I first opened up the door and observed the firearm on the floorboard area. For the jury, as you can see, it's
You can touch the screen.
Oh, okay. Sorry. So right here for the jury, you can see what I mentioned earlier, that the other firearm, it was a 9mm that was located, again, driver's floorboard leaning up against the center console area. That would have been, as you were driving, closest to your right leg, right foot area.
Okay. And then State's Exhibit 10.
So again, another photo. This is me just zooming in a little bit closer, just again highlighting, getting more kind of a more detailed photograph of the firearm itself. Again, for the jury, I will circle that.
And for the record, you collected that firearm?
Yes, I did.
And did you notice whether or not it was loaded or not?
Yes, it was loaded.
Do you know if one was in the chamber or not?
Yes, there was a round in the chamber.
Thank you. State's Exhibit 11. What's that photograph of?
That's a photograph of the firearm that I found on the driver's side floorboard that was leaned up against the center console. So again, the firearm, circle here, the firearm itself, the magazine, and then this round right here. When I recover a firearm for evidence and I unload it, I keep, if there is a round in the chamber, I keep that round separate. And that's why the way this photo is taken. So you have the firearm, you have the magazine, and then the round that I found in the chamber is circled all the way over there to the left, pushed up against the magazine.
And I'm going to show you at this point State's Exhibits 18 and 20. See if you recognize those two things.
Sure. So beginning with State's Exhibit 20, this is the magazine recovered from that firearm that's currently on that screen. And then all the ammunition that was in the magazine. Again, as you can see, packaged in one of our evidence bags that we use for the Warren County, for the Warren County Sheriff's Office, tamper-resistant seal up here, my initials, and then if you look here, that's the tag, the evidence label that I would have put on the bag itself.
And for the record, the one that you had, that's in State's Exhibit 11, the one that was in the chamber, that's the in that.
Yes, it's also in here as well. Yes.
So it was not separated out.
No.
All right, and does that, for the record, too, you put that in the same evidence locker back at the post that you did with all the other evidence?
Yes, I did.
Okay. Try State's Exhibit 18.
Okay.
Yeah, sorry.
Sure.
For the record, had that been opened?
Before cutting it, this bag had been sealed. However, prior, when I had my meeting with the prosecutor, this bag was opened to, again, as we were reviewing evidence, again, telling her that this is the firearm that I recovered in the defendant's vehicle on scene. So, again, this is the firearm I recovered on scene. It was cataloged the same way. This red seal, if you will, goes in through the magazine well, just to make sure that a magazine can't be chambered in there for safety purposes. And again, this tag right here is the evidence tag. It's attached to some part of the firearm, and then this white sticker right here goes on it. That's just what gets printed for our evidence collection. So that way it's placed on there and it's cataloged appropriately.
Same question, firearm seems to be in the same condition basically as the last time you saw it?
Yes.
And just for the record, those two items, 18 and 20, State's Exhibits 18 and 20, are the same items that you had pictured in State's Exhibit 11?
Yes.
Thank you. You can put that back. Okay. We'll go on then to State's Exhibit 12. Can you tell, if you get clear at the bottom left, you can clear that. Thank you. Why did you take the picture of State's Exhibit 12?
Sure. So when I was inventorying the vehicle, when I opened up the center console, I observed a closed bottle of Fireball whiskey in the center console. This is just me kind of taking an overall photo, so that way I can show the jury kind of the natural progression of the overall, and then slowly you should see a overhead shot of what's inside that center console.
All right, so
Real quick, I found the plea discussion. Crap. Got so many tabs open. Sorry, guys. Yeah, here it is.
There's been no significant plea discussions, right?
Well, no, I mean, he was technically ILC eligible on the felonies. The only thing that would not have been ILC was the OVI. But that's where we kind of started with this whole thing, and that he did not want to do ILC at that point. So there really hasn't been much beyond that.
So at this point, there is no offer extended by the state.
Well, I mean, it would be to plead to the, hold on, I have to go back to that screen. Where was I? Goes way back. Okay. And I'm sorry, while I'm looking for that, I'd also like to make a record that he has received the flash drive and that he has checked it out. It is operable. He can hear.
Okay, we're not that far. Let's take this one bite at a time, or we're never going to get it all off our plate.
I get that. I'm sorry. Wait a minute.
One bite at a time, or we'll never get it off our plate.
Handling with the forfeiture of the firearm. It would be a plea to the improper handling with the forfeiture of the firearms and resisting arrest. I'm sorry, and the OVI. And we would dismiss then obstructing and resisting.
Okay. With no joint and recommended sentence or no opinion on sentence from
I
the
don't think I want to do an agreement on sentencing at this point without getting a little bit more information from Sergeant Simpson.
Okay. Do you understand that offer, Mr. Riefers?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
All right. So
basically, he could have taken intervention in lieu of conviction, ILC. Basically, it's a way to factor the offender's request for intervention in lieu of conviction. So it's like a one-time thing, I think, where they kind of give you a break, basically. And he turned that down. Oh, yeah. Oh, yeah. Like the entire police force is under 18. So let's get back to the nerd.
Go to State Exhibit 13. Is that a picture of what?
Yes. So this would be, again, the open center console. And when I first opened it, I noticed there was a bottle of Fireball whiskey that was underneath a packet of Swisher Sweets and a lime green microfiber towel.
State Exhibit 14.
Nerd.
So at this point, I have taken the bottle of Fireball whiskey out to get a better photo of it, and have placed it on the. I placed it on the driver's seat to get another
That's
photo
unopened.
of it, just so that way there's a clear photo of what I was of what I saw and what I recovered. Or I'm sorry, not recovered, but what I located inside the vehicle.
Or
And do
at
you
the very
recall
least,
that
it's
bottle of
full.
Fireball was opened or had ever been opened, or if it was still never opened?
No, the seal appeared to be intact.
Thank you. All right, State's Exhibit 15.
I'm sorry, what did he say?
Said the seal appears to be intact. State's Exhibit 15.
I really like to think that was intentional, and he made her say it again. The seal was intact. This guy doesn't miss a trick.
Why did you take that photograph?
So again, another overall of a vehicle. It was my understanding that this vehicle had been involved in an accident prior to being pulled over. This was a overall shot of the right side of the vehicle. If you look over here to the, I'll circle it on the right rear quarter panel, you can see some damage to it. Again, this is just establishing an overall shot of that side of the vehicle.
Now, let me ask you on the next one. State's Exhibit 16.
So again, just for clarification, circling that, after speaking with deputies on scene in regard to the accident portion of this, it was explained to me that this was where the damage occurred during the accident. Just again, taking a better shot to, to showcase the damage to the vehicle post-accident.
All right, and 17.
So again, same photo of the right rear quarter panel, however, of a different angle. As you can see, again, it's partially displaced from the front side of the vehicle. And then you can also see scratch marks towards the lower half of the right rear quarter panel.
And without, disregarding what the deputies told you, you can't say how long ago this damage occurred on this car.
No, I could not.
You just took the pictures based on information you were receiving.
Yes.
Now, did you continue searching the defendant's motor vehicle?
Yes, I did.
And I'm going to show you State's Exhibit 21. Can you tell us why you took that particular photograph?
Sure. So this was the back portion, passenger compartment of the vehicle. I'll circle it right here. I observed a open/crushed can of beer, a Modelo, that I took a photo of. I did not proceed to pull it out. Just left it as is and took a photograph of it.
Can I just so I can picture this, is the driver's seat over here or over here? I mean, which is the going towards the front of the car, I guess?
Yeah, I want to say, should I see this photograph here?
You can tell me.
Yeah, I want to say that the front of the vehicle, believe would be in that direction.
So this is more like the rear hatch area?
Yes, yeah.
And State Exhibit 22, is that just a close-up of that same Modelo can you just testified to?
Yes, it is.
I mean, he's guilty for shit taste and beer, but
Why would we take that photograph?
So this is showing what I found in the trunk of the vehicle. In this case, it was a tan in color cooler. And then inside that cooler, I found additional closed containers of alcohol.
Alcohol?
Yes, of alcohol.
Okay,
Yes.
sorry. You had me on the edge for a second. 24, is that just another picture of that same?
Yep, again, just kind of establishing a shot that I am slowly working my way to the contents of what's inside that cooler.
And then lastly, 25,
Yes.
are
So-
those the contents that you found in the cooler?
Yes. So 2 unopened cans of Busch Light beer and another bottle of unopened Fireball whiskey.
And you know that one was also unopened and the seal had not been broken?
The seal, no.
Okay, thank you.
want to repeat that, sir?
When did you have, other than, well, you had the interaction of taking the defendant, escorting him to your cruiser.
Mm-hmm.
Did you have any further interaction with him after that?
No, my interactions, at least in regards to speaking with him directly, were limited.
Did you notice anything about his person that that you notated?
Yes. So while listening to him, though not speaking to him directly, based on my training experience in law enforcement over the 5 so years I've been in law enforcement, he appeared to be intoxicated.
Ladies and gentlemen, Deputy, I'm going to stop you. Ladies and gentlemen, we have certain rules regarding expert opinions and how those expert opinions are shared with you. That expert opinion has not been properly shared with you, and I'm going to instruct you to disregard that testimony.
So, Deputy, without going into any kind of training or anything, what did you notice about the defendant, just yourself?
Sure. What I noticed was that I could smell the strong odor of a alcoholic beverage, especially when he exited my cruiser. The smell was still there. I noticed that some of his speech was slurred.
Sit down, bitch.
And that he
Sit down, bitch.
was asking some of the same questions
down,
over
bitch.
and over again after being given a explanation.
And after the defendant was in the rear of your cruiser for a while, did you have an opportunity to get into your cruiser?
I did, yes.
And did you notice anything about the rear area of your cruiser?
Yes, I did. I noted the strong odor of an alcoholic beverage.
All right. Now, for the record, you did not transport this defendant to jail.
No, I did not.
Okay, so he was eventually removed
Props to
from your
Oda for
cruiser.
objecting
Yes.
there.
All right. And because you were continuing with your evidence collection.
Yes.
Hold on just 1 second, Your Honor.
I know, right?
Your Honor, that's all I have. Thank you.
Mr. Riefers, you may inquire.
Yeah.
Hey, Erica.
Deputy Peters, thank you for being here.
Mr. Riefers?
All right. A couple of things to kind of go through. I said you've got about 4 or 5 years law enforcement experience total.
Approximately, yes, sir.
You know how many OVI, DWI arrests you
What,
have?
he joined when he was
That I
8?
could not say. I do not know the specific number.
Okay. Have you ever arrested anybody and refused them a chemical test?
Yes, I have.
Did you just blatantly refuse it, or did they sign a refusal form?
What was the question again?
When you refused them a chemical test, did you have them sign a form that they were refusing, or did you just simply deny them the ability to take that test?
I have never denied the ability for somebody to take that test. I read them the B&B 2255 form and ask them if they would consent to a chemical test. Typically, I lead with one of the more least intrusive options, which is a breathalyzer.
Thank you. All right. We already went through all the stuff. You didn't observe the initial stop, correct?
No, I did not.
Okay. You didn't observe me resisting or any of that, correct?
One more question. I'm sorry. Can you ask it again one more
You didn't
time?
observe me like resisting or any of that. You showed up after I was already handcuffed, and then they just put me in here.
And then we escorted you to the car. Yes.
Thank you. And you said on the way to your vehicle, you were kind of helping me. I was limping. Are you aware of any prior injuries that I'd had? The 3 knee surgeries I had prior?
No.
Okay. So could it have been that the limping was maybe from being struck with the asp in that same leg?
Objection, Your Honor.
Overrule, answer if you can.
I would have no way to tell.
Okay. Is it standard procedure when you arrest somebody, you take their boots off?
Yes. It can be. Yes.
It can be,
Yes.
but it's not
But
in
I
the
have a
policy.
foot fetish, so that's just standard for me.
I don't believe there's any policy that says to remove someone's boots. No.
And then you photographed all the items in the vehicle?
No policy to
Yes.
say you can't
And you
stick
did
the
also
feet, though,
write a
either.
report, correct?
Yes.
Is it part of your policy that anytime you go hands-on with the subject or involved in an investigation, do an inventory, that you're required to write a report?
And you were too belligerent for them to offer you testing. Yes, Nidawau. While I'm more on this guy's side than not, the prosecutor really needs to be hammering that point. If this guy was a nutcase in jail, screaming, being uncooperative, all these things, would that be a reason you would be apprehensive to offer him a drug test because he could hurt you or hurt himself? Establish that. I mean, bring it up to the jury, for Christ's sake, woman.
I'm sorry. Can you ask the question again one more time?
Is it your department's policy when you're involved in an investigation and using force, going hands-on, or doing photographs, that you're required to write a report?
Yes.
Would it surprise you that Deputy McClellan did not write a report?
I don't know if you wrote a report or not.
And then you're talking about the firearms that you found. Okay. Do you carry a firearm off duty?
Sometimes, yes.
The firearm that you carry off duty, do
Are
you
you
have
old
to
enough?
go register it as a secondary weapon to carry it on duty?
Yeah. If it's if a firearm is different than what we carry on duty, we qualify with it. Yes.
Okay. Would it surprise you to know that Kel-Tec 380, the little clip, was the one I was carrying in the waistband when I was in the highway patrol?
What's the question?
Would it surprise you that that was the weapon I carried when I was in the highway patrol as my secondary weapon?
No.
And then you said that I kept asking the same questions, but you had stated that when I first came up that I was asking for a supervisor, correct?
Yes, you're at believe from what I recall, you're asking for a supervisor, and
I just
you.
need a yes or no, thank you. And you said that I kept asking the same questions over and over, is that correct?
Yes.
Okay. Was I not seeking clarity on why I was stopped?
Objection, Your Honor.
Overrule. Go ahead and answer if you can.
Yes, I believe. Yes.
No further questions, Your Honor.
Deputy Peters, can you tell the jury, how do you know that's why the defendant was asking these questions repeatedly?
I'm sorry. Can you ask the question again one more time?
Because they
You
weren't
said
giving him an
You
answer.
agreed that he was seeking clarity by repeatedly asking questions. How do you know?
He kept asking the same questions over and over again. He was given answers, though, due to from
Really?
what it appeared to be his
Really?
intoxicated state. It just wasn't. It didn't seem to be. The answers we were giving him either weren't good enough or just simply weren't registering.
All right.
And is this on video or audio somewhere? Oh, no. Shucks. I heard him scream several times, oh, what's the PC? What's the PC? I never once saw anybody on video explain what the cause was for arrest. I mean, they had PC, but you still need to tell them.
So when we say clarity, I mean, it could be because he's intoxicated or it's because he just had he wanted more clarification.
Yes.
How do you know which one it was?
I don't know.
Okay, because you're not in the defendant's mind. Is that fair to say?
Yes.
All right. Now, you said that you've never refused anyone like any type of breathalyzer or any kind of test on an OVI stop. Does it depend on how cooperative that person is?
Good.
Yes, it can be.
And then you also indicated that sometimes you do
That's it?
remove footwear. Can you just tell the jury why would you remove
That's
someone's
it?
footwear?
So in this situation, because
You weren't going
a
to tell the
firearm was
jury
found
how
on his
get him
person,
tell how uncooperative he
and
was.
the shoes that he was wearing could potentially conceal additional contraband or weapons. The boots were removed to verify that nothing was inside.
And then you indicated that you are like every deputy that is on the scene, even if there's like 25 of them, are required to write individual reports?
In my experience, it's going to
No.
depend on your level of involvement, and sometimes it also comes down to whether or not a supervisor is going to want you to write an additional supplement. Again, it depends on what your overall involvement is with the incident.
So if you're not very involved, then not every deputy has to write a report.
No.
I wonder if that could have lost it for her.
When we talked about taking the boots off, whether it's standard or not, couldn't it have been just
Oh,
as
no.
simple as you check there's no weapons in the boots and then put the boots back on while we walked across the road, rather than drag me across the pavement with them?
I don't believe you weren't dragged across the pavement.
But we could have just put the boots back on and go across the pavement, right?
Can you ask the
What?
question again one more time? I'm sorry.
They
the
could have
boots
just put my
back
boots
on?
back on me to go back across the pavement.
In my experience, once I take someone's shoes off, it is very rare that I would put them back on, just simply for the fact that I would prefer not to be near someone's feet that is currently in custody out of fear that they could
I
kick me.
understand. Thank you.
Out of fear of sexual arousal.
To summarize my point, typically when I remove someone's shoes, it's going to be rare that I put them back on. I have, in my course of duties, provided that courtesy to somebody depending on the situation. However, when they get to the jail, their shoes are going to come off regardless. So
After
whether
I
they're put
take
back on
pics
or
for
whether they're
Feet
taken off
Finder.
and not put back on or just taken off entirely until they get to the jail, it really doesn't matter. But typically in my experience, especially with
Weirdo.
this specific incident, I would not feel comfortable trying to, take my hands away from, being able to, defend myself from someone's legs to help them, put shoes back on. At that point, I believed it was a moot point. It wasn't necessary. The boots would have come off regardless. So there was no need to put them back on.
David, does the prosecutor have anyone in her life that loves her or cats?
And then while you're taking photographs of the vehicle, Deputy Carter comes back while you're doing the inventory. You remember that?
Objection beyond scope.
I'll sustain the objection. You have to confine your recross to the questions that Ms. Hyatt asked on her redirect.
Yes, Your Honor. And I have no further questions, Your Honor.
Thank you, Deputy. You can step down. Next witness.
Your Honor, the state would, with the admission of the exhibits, would rest at this time.
All right, ladies and gentlemen, we're going to take a break. Even though the state is rested, you don't know enough about this case to start thinking about how it should be decided or begin talking about it amongst yourselves. Ms. Brooklyn is going to take you back into the jury room. I'll see you back here about 11 o'clock.
Your Honor, if I may. But, never mind.
Yes, Your Honor.
Go ahead.
Want to submit this now for acquittal?
I'll talk about it in just a minute. Exhibit.
All right, this time I would just resubmit my Rule 29 motion for acquittal.
All right, let's talk about exhibits first.
You want to submit this now or?
We'll talk about it in just a minute. Exhibits. Exhibit 1 is the one call. Exhibit 5 is
Yeah.
20 photographs.
All right, and the 7 is the doorbell.
Mr. Riefers indicated that Exhibit 5, there was the 14-minute clip that Ms. Hyatt played, that even though Mr. Riefers had the full video, he did not have the 14-minute clip. Am I summarizing that correctly?
Yes, Your Honor.
All right, and I did overrule that objection at sidebar, so 1 through 27 will be admitted. All right. Mr. Riefers?
Yes, Your Honor. This time I would move for the Rule 29 motion for acquittal.
Okay. Is there anything additional you want to tell me other than you can approach? Anything additional you want to tell me other than what's in this writing?
No, sir.
All right, court finds when the evidence is viewed in light most favorable to the state that it is sufficient to sustain a conviction. So I am going to overrule the 29 motion. What's next, Mr. Riefers?
Your Honor, it would be to call for Deputy Roberts if we're doing that after lunch, or
Okay, well, I see some folks drifting around out in the hallway. So why don't we take a few minutes and you figure out who's here, what they're going to say, because I don't want to call witnesses that aren't going to say anything. Talk to them, see what they're going to say. We will resume, and then you can begin calling your witnesses.
are we just a few minutes, or are we resuming after lunch?
We'll be back at 11.
Okay, gotcha. Yes, sir.
Okay? All right. Do we have?
This time, Your Honor, I'm ready to move forward with closing argument.
Oh, really? Okay. That's not what I
Oh,
was.
so your arrest?
Yes, Your Honor.
Okay.
Oh,
1 second, Your Honor.
you just threw her for a loop. I like that. Oh, she is scrambling right now to write her closing. I wonder if she thought he wasn't even going to do it today or get to it.
Your Honor, may I ask a question?
Sure.
Mr. Riefers is torn between testifying and his closing argument. The question we have is how far are you going? How much latitude will you allow him in his closing?
I don't know that I understand the question, but if Mr. Riefers wants to interject evidence into the case through his testimony, then he needs to testify. If he wants to give a closing statement or a closing argument about the evidence that has already been presented, then he can do that. But the evidence that he presented in his opening, that he was a veteran, whatever, man of faith, the former trooper thing is in evidence. You know, all of the history and the background about Mr. Riefers, that's not in evidence, so he can't argue it in his closing.
Yes, Your Honor, I'm just referring what they had stated while they were up for testifying. I can use that in my closing.
Yes.
Okay.
Interesting. I like this standby counsel.
Does everybody have any instructions in front of them?
Yep.
All right, I did delete the stuff about expert witnesses.
Saw that.
And
I'm going to skip the
I'm going to put the testimony of the defendant. It's not necessary for the defendant to take the stand. Contrary in. So let's plan on being here back at 25 after. Come back what a different side has to sum up for you what they think the evidence has shown and argue to you for a specific verdict. We have agreed in advance that each side is going to have up to 30 minutes to present their closing arguments. Ms. Hyatt, because she has the burden of proof in this case, will address you both first and last in the case, with Mr. Riefers addressing you in the middle.
Okay.
The one caution that we do have that I've already given you this instruction, but I want to remind you again that Mr. Riefers has the absolute constitutional right to remain silent in the case. He doesn't have to testify in the case. But he's not presented any additional evidence in the case. So what he tells you is only in his capacity as an attorney representing himself, is not substantive evidence in the case. All right, Ms. Hyatt, you may proceed.
Thank you.
That is just brilliant by him. He made her think he was going to call all these people. He was going to testify. He was going to do all this stuff. And just the second he gets the ball, he's just like, I'll rest. I'm done. Closing. Let's do closing. And now she has to scramble. She is not ready at all. Brilliant move. Brilliant.
I'm going to use a PowerPoint.
Get plugged into your computer.
Yes.
Sure we can do this.
Thank you.
You just threw her for a loop. That is just...
Good morning, still. Ladies and gentlemen, as we talked about yesterday, we're here because of the really bad decisions this particular defendant made, especially in the evening of November 9th of 2024. You heard all the evidence in the case. And again, I just want to remind you, evidence is not what he said in his statements to the officer or to any of the witnesses. If the witness didn't agree with the defendant, then that is not testimony from him. So it's only what you heard from the stand. I just want to make sure, because it kind of got a little blurry there as to what he was saying and whether or not they agree. If they didn't agree, then what he said is not evidence. But I want to talk a little bit about the fact that who did you hear from? And starting off with, you heard from Lindsay and Robin Davis and Ashley Burns. They were here primarily just to give you an idea of what was going on that day. What had they been doing? What did they observe about the defendant before he left their house for the final time and then encountered Sergeant Simpson? Because this case is all about what happened with the encounter with Sergeant Simpson. That's where these charges are all coming from. However, you can't just always look at it in a bubble. And in this case, I wanted you to hear what this defendant had been doing. Now, you heard from them as to where they had gone, what they had been drinking. And I want to just point out that Robin especially was able to tell you not only the type of bourbon this defendant had bought and was consuming, but how many drinks he saw him consume. And he mentioned, and I'm not even talking about a couple of beers or so at 50 West, but at the Davis house that evening after they came back from 50 West, Robin told you this defendant drank approximately 5 straight bourbons on the rocks, which is fine if maybe you weren't driving. And it may not affect a lot of people. But in this case, it affected him. And how do we know drinking that much bourbon, down to about a third to a half of the bottle of bourbon, how do we know it affected him? Because when you get the definition of under the influence, it has to be an adverse effect on a person. And in this case, you heard he started off that morning as a nice guy. They thought he seemed to be a decent human being. And I'm not saying he's not a decent human being as he's sitting here today. But that morning, going into that afternoon,
Wow.
They all thought he was a decent, or seemed to be a decent, nice man. But when he started consuming the bourbon, and more bourbon, and more bourbon, and more bourbon, what happened? They told you his demeanor changed. And it did not change for the better. It changed drastically for the worse. And Ashley told you, through her video depot, he started getting more aggressive, wanted to have sex, kind of was expecting thing. This is their first encounter face-to-face. Davis has told you as well. He got angry when they told him he had to leave. He kind of slammed down his backpack. He went out in a huff. These are adverse effects of the bourbon on that defendant. That's how we know
Johnny.
the bourbon was adversely
Nibbles.
affecting him. He was under the influence of the bourbon he consumed. They also told you that he was so aggressive or concerning that they were scared for their safety, that they all armed themselves when he said he was coming back. And when he did return, they were so concerned for their safety, they felt compelled to call 911. Not just turn him away, call 911 because they felt that unsafe. That's the adverse effect the bourbon had on this defendant. Now let's talk about the encounter with Sergeant Simpson, because you do have the cruiser cam. I wish so badly that they had body cam back in November of last year. They didn't get it till March of this year. But back in November, if they had it, I think we would have had a whole different situation. You would have had a lot more that you could see. However, what do we have? Sergeant Simpson told you that when he was first told about the 911 call from 5539 Old Farm Drive, which we all know is in Warren County, that it was for a disorderly, intoxicated male. En route, he's getting continuously more information, because in that 911 call, you heard you heard Lindsay telling the dispatcher, they're asking for more information. What was he, what's he wearing? What's he driving? What's he doing? What was he doing before? She's trying to provide information. That information is then broadcast over to the officers that were on duty that night. Everybody can hear the dispatch. But en route, Sergeant Simpson told you he was informed this male had been trying to get into the residence and had been verbally aggressive, that he was a Texas or former Texas law enforcement officer of some type, and he was driving this white Toyota Highlander SUV, which in fact, as Sergeant Simpson is trying to get to 5539 Old Farm Drive, he finds that car, lo and behold, parked at the intersection there, that T intersection, as he's going towards the Davis residence. He turns around because he suspects that's the one I'm here about, that he had left the residence and had been going towards Snyder. That was on the 911 call, that he had been heading towards Snyder Road, and that had to most likely be the same car. He turns around, and what does that motor vehicle do? It turns left, because that's the only way you can only go left or right, turns left, and on Sergeant Simpson's cruiser cam, when he lets off his brake to take that turn, there is no turn signal flashing.
You can only turn left or
right. No
right.
matter what he tries to have you tried to show you, the cruiser cam is not going to lie. You look at the video. That will tell you what's going on. There is no flashing light. So there you go. That is also, lo and behold, a traffic violation. So not only do we have an investigation on the 911 call that Sergeant Simpson is compelled to do as a law enforcement officer, because if he's not compelled to do, he can't just willy-nilly decide, I'm going to go to this one and investigate this 911 call, but no, I'm not going to do that one. No, they have to investigate every call. And now he also has a traffic offense that he physically witnessed as another reason to stop that motor vehicle. And what did he tell you at this point? He also sped off. Now you had it. It was not a long period. It was a fairly short one. But he did speed off, and you saw Sergeant Simpson's cruiser, how it had to respond to catch up. And then when he turned on the lights and then had to chirp the siren, this motor vehicle stopped. And you can see on the cruiser cam too, it does come to kind of an abrupt stop. And then you have Sergeant Simpson calling it in. You can hear that as to the plate, starts to control the plate, or starts to call in the plate, but stops. Now, what caused him to stop? He started to see that furtive movement inside the car and decided he needed to investigate. Starts walking up, and on the cruiser cam, I want you, if you don't remember this, if you want to watch it, he's walking up to that driver's side of the cruiser cam, and all of a sudden he kind of almost flinches and hesitates, and then continues. That's when that defendant was either punching the windshield or punching at the windshield. Sergeant Simpson sees that action and instinctively hesitates. Another concern, you have an angry individual inside this SUV who supposedly has been disorderly and is intoxicated. At this point, what does Sergeant Simpson do? He's asking for backup to start stepping it up because he's not sure what all he's going to find. Sergeant Simpson told you how when the defendant did roll down his window, there was the strong odor of alcohol coming from this defendant sitting inside his motor vehicle. That not only that, when he asked the defendant, why would your friends call? He refused to answer. According to Sergeant Simpson, he was staring straight ahead, refused to answer. More importantly, when Sergeant Simpson asked him, do you have any firearms? He refused to answer. He's supposedly law enforcement. Now, Sergeant Simpson at this point is in a very dangerous situation because he has an angry, intoxicated drug male who probably has a loaded firearm somewhere because he's law enforcement or former law enforcement. He cannot let him sit inside that car. He can't stand at that window and have the ability of this man to suddenly pull out a gun. And where were those two guns found? In his pocket, easily accessible. And oh, by the way, sitting right when he's in the driver's seat, right there at his right foot. Very accessible. Imagine how quickly he could have gotten a shot off at Sergeant Simpson if that had happened.
But he didn't.
Sergeant Simpson then demanded that he have this defendant exit the motor vehicle. And then you see what happened when he did. Unfortunately, we can't hear the body cam or body mic as we did as well as on the other deputies. But you can, at some point, when the level and the volume of the yelling is loud enough, you can hear excerpts of what's going on. But what did Sergeant Simpson tell you was happening? He's trying to detain this defendant. This defendant was not free to walk away or drive away from the scene. He's investigating the 911 call. He has a traffic offense that he has to also investigate as well. And there's certainly a lot going on here. You've got a man who's angry, who appears to be intoxicated. He's punching, he's not answering. There's a lot for this sergeant to be dealing with because this is his job. He has to let that happen. This defendant was not free to go. I'll tell you that right now. He was being detained until Sergeant Simpson could figure out what was happening. When he tried to get him detained, because he is a large man, and Sergeant Simpson was by himself, he wanted to cuff him. Again, we don't know if he has any loaded firearms on his person. He now has seen the clip, which he thought was a knife. Turns out it was a clip to a loaded firearm, but he thought, if nothing else, he could have a knife. And I don't know if you've ever seen this, but it does not take much for somebody to come at you with a knife and get to you before you have a reaction time. So when he tried to grab the defendant's arm to put him into cuffs, what did this defendant do? Kept pulling away, which caused even more concern because now you heard him say, I've got one resisting. And you heard that in his cruiser cam video, but also on Deputy McClellan's cruiser cam as well. You could hear, I've got one resisting. He tells him he then has to take out his taser at this point because this defendant is not complying with Sergeant Simpson's orders. He repeatedly ordered him to get on the ground. He refused. So the only thing Sergeant Simpson could do at this point, because he still didn't have backup, and this was unfortunately a night where there was a lot going on in Deerfield Township and people were not able to get to him. And you can look how long it took before that first cruiser came. And even when Deputy McClellan and his crews are driving there, that's a long time for somebody to be actively involved with a large man who is refusing to comply and who is intoxicated. He then tells him to turn around and put his hands behind his back, solely for the purpose so he has more reaction time if this defendant will whip around with any kind of weapon. The defendant does comply with that to some extent, but he doesn't just stay in that position. If he had just stayed here, we wouldn't have all the charges. We still have some charges, but we may not have all the charges at this point. However, he doesn't. He can't help himself. He is that under the influence because he's former law enforcement. I dare say, if he had rolled up on him acting like he was that night, he would not have wanted to deal with that. And he would have been just as upset about that and having to do the same steps Sergeant Simpson did. He's law enforcement. He knows better. He knows he should comply with officers. This should have been an easy, relatively easy stop, except for him. Sergeant Simpson, though, he comes at him. He tries to, and it comes up to the point where he has to physically push him back. And that's where you see the defendant come with him with both hands with this, coming at Sergeant Simpson. And that's when he's tased for the first time. And then he's able to pull the tasers out and goes around to the car. Sergeant Simpson is able, he's still not complying. We still at this point don't know, does he have a firearm? Can he shoot me? Can he stab me? Sergeant Simpson doesn't know. He can't let him go be out of sight where he doesn't know what's happening. So he arms his taser and shoots again. Defendant rolls on the ground. When Sergeant Simpson tries to go towards him, you saw him actively kicking out at Sergeant Simpson. So the Sergeant Simpson is not getting kicked. Defendant then gets up, and they're so close, and it's so quick. He immediately, all he has left is the dry stun. He does it very quickly. Defendant starts to run around to the front of his car again, out of sight, and that's when Sergeant Simpson uses his baton and finally is able to get this defendant on the ground like he had been trying from the beginning. That's the only way he could do it.
I'm here, but I'm not.
When he tells, and you can hear it,
having my
even
camera
on
on.
Sergeant Simpson's cruiser cam, get on your stomach, get on your stomach. Does he? No. No. He
I
is
hate this
still
woman.
refusing. He is still resisting. He is still not complying. Until those other deputies come around and they finally pull up, and you saw they ran to Sergeant Simpson's side, and you heard their body mics. Get on your stomach. Get on your stomach. And again, he had to be forcibly rolled over onto his stomach, had his hands underneath him at this point. Now, as dangerous as that was, because he did have a loaded firearm right there, right on that clip. And he had to be, did he put his hands behind his back when they said? No, he had to be forcibly pulled from underneath him in order to be cuffed. And then at that point, he was finally secure and could be searched. And lo and behold, not only was the loaded firearm found, but the knife was also found on him as well. And then when his motor vehicle was searched, another loaded firearm that was so accessible to him when he was sitting in the driver's seat was also found. Each one of those firearms had a round in the chamber. He wouldn't have had to rack it. All he would have had to do is point and fire. Let's talk a little bit about what I have to prove to you beyond a reasonable doubt in this case. And I'm not technical, but I'm going to try to do this. First count is improper handling of a firearm in a motor vehicle. On about November 9, 2024.
I hate this woman.
We all know it happened in Warren County. We all know there was this defendant that was involved in this situation.
Hi.
Question is, did
Can you hear me?
Yeah.
Oh, okay. Sorry. Like, I'm not turning my camera on today. I look like shit. But I hate this woman so much.
Fair enough.
And I can't find my hairbrush, and I've been making fun of her all day. So
Well,
I am about to come on and have my hair look like shit.
Okay.
But I just wanted to say I hate her so much.
she is definitely getting under my skin.
She's just making shit up.
Yeah.
She's making shit up. She's like, she just said, oh, I'll tell you, he was not free to go, right? Well, there's no proof he was not free to go because there was no audio to go with that dash cam. She said there was a body cam. There's no fucking body cam.
Dash cam, but none of the body cam really, well, they didn't show any of the initial confrontation between the two, what was said.
She said the word body cam. There's no body
Yeah.
cam. right? So she was referring to the dash cam.
Yeah.
She said you can hear a bit from the dash cam, right?
Yeah.
Well, she said you can hear a bit of audio from the body cam, which she meant the dash cam, right? And then she said, "Oh, I can tell you right now, he was not free to go. He was detained." Well, there's no proof of that because Muggins, idiot, old mate, didn't turn on his body cam, which would have proven that he said that you're detained, right? So she's just making shit up. No, Luis.
Yeah.
No.
And did Brandon testify? Nope. He just went up and went, I'm going to go to closing. And the prosecutor got really flustered and was like, oh, well, I and starts like writing stuff down furiously and was not
Sent
ready
her
for
a
him
loop.
to.
It was
Yeah.
fantastic. You should have seen her face. It was great. She was just like, "Oh, okay. So we're going to going to closing." She's like, I didn't know that." Like she actually lost it. It was great. Hey, also one thing. So some people are saying that there's body cam. Paul's Hygiene says, "Helen, don't worry about your hair. Get your ass on cam." No. There was a body cam, but they called for the body cam after it was deleted months after. But I mean, as far as the jury's concerned, there's no body cam.
Yeah.
So no, there's no body cam. Yeah, I believe you, but yeah, it's not in evidence. So
transport or have unloaded firearm handgun in his motor vehicle when he was under the influence of alcohol. That's it for improper handling. But knowingly is going to be defined for you. And again, it's one of those definitions that I guess I really wish these people would have to be talking to juries more often because the definition gets really wordy. But it's essentially, it's like you look at all the facts and circumstances that you.
Princess, it's your job to explain the jury instructions to the jury.
Have what you've been from the testimony and determine whether or not that defendant was aware. Was he aware of the probability, not that he was, but of the probability that he was actually transporting guns while he was under the influence? Now, I'm going to submit to you, he doesn't have to admit I was under the influence, but he knows he had 2 loaded guns on him or in his car, and he knows he'd been drinking quite a bit of bourbon. He can't deny that. That it was a firearm, and you're going to have like a little report. We've stipulated to the fact this was a firearm. That if you had fired that .380 that was in his pocket, or that 9mm that was on the floorboard right by his foot, if you had actually fired it, pulled the trigger, it would have expelled the projectile. It is operable. That's what makes it a firearm. So that's been stipulated too. But you will have Sergeant Dottie's very brief report where he went out to the range and shot both of them, and they worked. Now, excuse me, you're also going to be given the definition of under the influence because we have to show that he was under the influence of alcohol. Likely alcohol, I don't think we have any information that there was a drugs that had been taken, at least not that was observed by any witnesses. But under the influence is when alcohol adversely affects and noticeably impairs a person's actions. In this case, I think we've already talked about the change in demeanor and the fact that if he had been in his right mind, if he had not been under the influence, he would not have acted the way he did that evening, especially as former law enforcement. You're also going to have that it was one of them's concealed on this person. So we have that. Oh, I'm sorry. I figured we do little checks. Is concealed on this person. So this is going to be your definition that you're going to get. But again, it shows that the consumption of alcohol adversely affected and noticeably impairs his actions, his reaction, or his mental processes under the circumstances then existing, depriving him of the clearness of intellect and his own self-control, which I will submit to you was non-existent. He had the gun in the car. Count 2 is, we didn't go into the forfeiture specs, but if you find the defendant was guilty of count 1, there are 2 forfeiture specifications that accompany that. We had to show you by clear and convincing evidence, not beyond a reasonable doubt, but still, we have to prove to you that he used, that these guns were the instrumentality for this offense, that these guns were used by the defendant in order to commit this offense, in which case he had to have the guns in order to have improper handling of guns. So those were used as the instrumentality of the offense. Count 2, though, is very similar. We still have the same date, location, him, and that whether or not he was getting under the
Him,
influence of
date,
alcohol,
location,
same
him.
definition. Did he have a firearm? In this case, it's the same basic thing as count one, except we don't have to talk about if it was in a motor vehicle or not. Just
She's struggling.
bottom line is you cannot have a firearm if you've been drinking to the point where you're under the influence.
Mush
Where
mouth
your
idiot.
faculties, your mental faculties, your ability to make good decisions, your ability to exercise self-control are not affected. If they are,
She's doing an
then
okay
that's a
job
crime.
considering she has to
No,
scramble.
she's not. She's doing
Obstructing
shit.
official business. Again, same date, same location, same defendant.
I want
Did
to see
he,
the
without
PowerPoint
privilege, to do
slides.
so? He had no right to act the way he did.
Oh, yeah.
He did not have a
I'm
privilege
so
to do
annoyed I
that.
don't get to see him.
And with purpose to prevent, with
Wonder if I can
purpose to
spoil the
prevent, obstruct,
PowerPoint.
or delay the performance of any
Wonder how many
public official, in
typos
this
are
case,
on it.
Sergeant Simpson. You're going to be given the
Probably did it
definition
over lunch.
purposely. I'm not sure if that's there. Nope. Okay.
I reckon it's got a jigsaw
The
puzzle.
purposely
Whoa.
is the, I'm not sure if that's the official, in this case, was Sergeant Simpson. You're going to be given the definition of purposely. I'm not sure if that's there. Nope. Okay.
You're going to be given the definition of purposefully. Next slide. I'm not sure if that's there. Oh, nope. Okay. Well, I guess I don't have it on the PowerPoint. Okay. Good Lord, girl. I did a better book report in the 11th grade.
She had 20 minutes, man.
Couldn't even remember what slide she put in there.
I wish you could see him on here. He must be giggling. Suffer.
Are there other trials to see her in? Yes. Well, it's I've seen the same kind of prosecutors in this whole courthouse. So I'm sure we'll see her again because I plan on covering more trials from this area. She's in court often, yeah. It could be she assumed an easy win against a pro se. They often make that mistake. I think the prosecutor made that mistake with Lori Vallow. The prosecutor was a little unprepared when it first started. And they definitely made that mistake with Ty Tucker.
It was lucky that the jury was tainted.
Yeah.
Yeah.
So it's just funny.
But purposely is the specific intent to obstruct or delay a person's law enforcement duty. It has to have a specific intent to do that. I submit to you his deliberate refusal to answer questions, his deliberate refusal to comply and get on the ground or stand there with his hands behind his back, having to be tased 3 times, having to be hit with a baton, having to be forcibly put on your stomach and grab your hands behind your back. Those are all specific intents.
Mm-hmm.
He knew what he was doing and chose to do it anyway. Again, I submit to you because of the amount of alcohol he had consumed that evening. And the fact that his actions did impede, it delayed. Look what Sergeant Simpson had to go through for what should have been a much more simple traffic stop. It delayed his ability
Mikey.
to do his job. Then,
How you doing?
lastly, whether or not it caused a risk of physical harm, not serious physical harm, just physical harm to Sergeant Simpson. Was there a risk? Which judge will tell you a risk is a significant risk. It's not just a little bitty teeny risk. It has to be a significant risk to Sergeant Simpson's safety. Could he have been harmed? Not that he was, but could he have been? And I submit to you, you've got the pictures when he's coming at him with the fists before he was tased. If he had been hit, what about when he was being kicked at? He could have been physically harmed that way. And physical harm can be any harm. Physical harm can be a little bit of a bump, can be a slight red mark, all the way up to something more serious. But physical harm, a risk of any type of physical harm to Sergeant Simpson, if you believe that could have happened, then you would find him also guilty of that as well. And I submit to you, everything that defendant did that night was a risk of physical harm to Sergeant Simpson. You could even hear in Sergeant Simpson's voice, his concern. I don't want to say fear, concern for his own safety. Resisting arrest, again, date, location, defendant. Did he recklessly or by force resist or interfere with the lawful arrest of himself? Again, recklessly is another one of those silly definitions, but it shows that was he aware that his actions and his decision not to comply with Sergeant Simpson's order, was he perversely disregarding the known risk for that? Did he know that he was, he knew that he was perversely disregarding the order. He was not complying. It was not something that was negligible or he didn't understand that wasn't happening. And that his actions was for the resisting or interference of his own arrest, for the obstructing, for his non-compliance with the orders of Sergeant Simpson. And I would certainly say by the time the two deputies got there as well, he was certainly not, he was actively perversely disregarding.
Actively perversely disregarding?
Show him his hands. He was definitely under arrest for that.
Well, he was definitely under arrest.
The stores?
Here's him coming at Sergeant Simpson, having to be pushed back, coming at him again, kicking. Last count is OVI. And we have to show to you again, date, location, person. Was he operating in his car while he was under the influence of alcohol? It was not a very long period of time seeing him driving. We did see that kind of like a little lurch on the stop, kind of took off a little bit, but not for long. But what do we know? He was operating the motor vehicle because he came out of the driver's side. The question is, was he under the influence? And I think we now would submit to you, based on everything he was doing that night, what he had done before he left the Davis's house, how much he consumed, whether or not that, again, that bourbon had adversely affected his ability and his actions. And in this case, ladies and gentlemen, just strictly for how he acted when he got out of that motor vehicle, he was under the influence of alcohol. That was adversely affecting every decision that man made on the evening of November 9th of 2024. So he was driving that motor vehicle under the influence. I'm just going to sum up that Judge Oda will give you the law in this case. I'm just giving you some definitions. I want you to listen to them. These are the elements I'm supposed to prove to you beyond a reasonable doubt. Plug in what evidence you believe has been shown, weigh it, and determine whether or not I have proven to you beyond a reasonable doubt, each and every one of those elements. I submit to you, though, at the end of your deliberations, that the evidence does, in fact, convict this defendant. His own actions convict himself. And we ask that you find him guilty as charged of each and every offense. Thank you.
Mr. Riefers?
Thank you, Your Honor.
Everything that guy just says is bullshit.
Thank you.
All right. Well, ladies and gentlemen of the jury, we've come to that moment I've been waiting for. So the very best thing to do is I'm just going to walk you through a little bit of this video.
Additional unit, 18 or 30 hours, 2336.
Okay, so that's what I was trying to point out earlier is when he was first walking up, you can see the window was already down. Okay, if we back up, this is before he walks up. You can see clear as day in the car, not moving around, not punching stuff. All this stuff just kind of added after the fact.
Able 80 or 30. 80 or 30 Alpha Vehicle on Homestead, request additional unit. 18 or 30 hours, 2336.
So there, a minute 40 in is when he's stopped me, right, approached the vehicle. Back for a little bit.
Clear 5796 Homestead.
So turn off the internal audio because this would be the body microphone, which is the body microphone that's not working. But here we're just talking. He's asking for license, insurance. As he said, going to court, first thing he said was, come up, why'd your fence call? So I've done, Highway Patrol did a lot of stops. You don't do that. We go through a procedure of things. This is the reason to stop. This is what I need. Pretty simple process. But what we're coming down to is they keep talking about everything that's happened. When we go through this, and I'll just skip ahead for you. Okay, 302. Come out of the car.
Arguing during notification?
6, 7 seconds later, that's when it goes to grab you. That's your traffic stop. That's where he says, I'm under arrest for obstruction. And you gotta ask yourself, what am I obstructing? I simply got out and said, what'd you stop me for? He didn't tell me anything. He goes to grab me. Understand officer safety. They want to check weapons. That's fine. I've done that to thousands of people. You just articulate. Hey, just want to pat you down, make sure you don't have any weapons for my safety and yours. Very simple process. That's all we're after. And as you see as he goes further, he starts pushing into me. I'm going, what are we doing? What's going on? I'm still confused, going, what's happening here? Then we'll go a little bit further as we start to argue. He tells me to turn around, put my hands on the back. That's what I'm doing. Well, while we're standing there, he's either going to come up and arrest me, go hands on, or we're just standing waiting for other units. Okay, so while we're standing, I'm trying to go, what did you stop me for? What's going on? Why are we here? Nobody would just tell me what the stop was for. That's what we talked about. He doesn't bring it up until 40 minutes after the stop, when I'm already arrested and in the back of the patrol car. This entire traffic stop was a minute and 28 seconds, a minute and 32 seconds long. In that time frame, that's when you got to establish, am I under arrest for obstructing, and what did I obstruct? Simply asking why I was stopped, seeking clarity. Then when we go further into it and start walking towards his car. So you're trying to understand what's going on. Like, I'm still confused. Well, it's like, okay, you want me to turn around and put my hands on my back? We'll do that.
And I'm going to just object because he did not.
Yeah, ladies and gentlemen, I'm just going to remind you, the video is the evidence, not what Mr. Riefers is saying. Go ahead, Mr. Riefers.
Thank you, Your Honor.
I look very Harry Potter today.
See, we're saying, what do you want? You want to turn around, put my hands back? What are we doing here? Then that's when I asked him about his body mic there. Do you have the body mic on? Pointing at the body mic in the chest. Okay, I realize he's there about an intoxication or thinks I'm drunk. Okay, let's go do it. Let's do it. That's what I'm going to do. That's when I walk over to the car. That's when he pushes me. He's the one that advanced. I was seeking clarity this whole time. Then I want to go to a little bit past this here. Get the second one there. You see where he comes up on the second. And then we continue on here on the ask. I'm facing away from him, hands up. You stay over there. I'll stay here. We'll wait for these other units. Just quit beating me. You hit me twice with the taser and then dry stun me. You ain't even told me why I'm stopping. Then you come up and hit me with an ass baton to take me down. Do you think when I get on my back, and all I'm hearing is him get down, get down. Do you think in that moment, that high stress, you're going to be going, oh, he's saying roll over in your stomach? No, you're in fight mode. You're like, what's going on? Why is this even happening? That's all I really wanted to kind of show you guys with all that. Oh, and the other part where they talked about once I'm down on the ground, you see, I'm just like, dude, leave me alone. Go through all that, trying to understand what's happening. Here comes the other units. 707, they're coming up.
You can't really testify.
Got me on my stomach. 711. 714, hands behind my back. Did I really resist them? You think maybe it took 3-4 seconds because one's pulling me to the right, one's pulling me to the left, and not coordinating? It was about 3 seconds while I was rolling my stomach before they got my hands behind my back. All right. You also heard from Ashley, Lindsay, and Robin. Ashley's original
She's not objecting.
that she made to Deputy Hale and Deputy Carter never mentioned anything about the wrist grab,
but then you
sex,
just
or
go
fear.
back
Only
doing
months
it
later in
anyways.
depositions that suddenly appeared. She admitted she'd been drinking bourbon and beer and has a TBI that affects her memory. They also admitted that we've been drinking about the same amount that night. All 3 witnesses stated 1 to 2 drinks on lunch, 3, and then Robin kind of stretched it at the end there, maybe possibly 5 drinks throughout the evening. So let's just do simple math on that. If you take the highest number, it's 5 drinks over the 4-hour period that we were there that they're referring to from 7 p.m. until they left at 11 p.m. That was when we were having dinner. It's 4 hours, 5 drinks. Rule of thumb is usually 1 drink an hour. That means at that time, we only had 1 drink in my system. That's why I was so adamant about doing the chemical test. Give me the option to prove to you that I'm not intoxicated. He denied me of that right. You heard it directly from Deputy Simpson. He never offered me a chemical test, but they are required to collect all exculpatory evidence. He just didn't do it. That's one test that would have just simply settled everything. Do a blood, breath, urine test. They've got nurses at the jail, other deputies. They could have somebody else come run it and give me a chance. That's what I was after. That's why I kept going after that 1:30 to 4 a.m. missing window of video that the state had first, but then now it's gone. At the jail, I begged again for the test. And then Deputy Roberts said he called Deputy Simpson and just said he wasn't going to come back. And Deputy Simpson, he admitted himself on the stand that he had been written up for conduct unbecoming. He admitted that he had gotten written up for mishandling of evidence in a firearms case. He admitted to arresting someone that it wasn't even an arrestable offense. He admitted that he did not offer me a chance to have the test. Those are his words, not mine. That's what he said under oath.
That part
So
is
what we want to
that
point out
is
is what evidence did they have? Deputy Simpson didn't take blood, breath, or urine. He did not document my repeated requests. What he did instead, he took my state retirement badge and my credentials. That's his evidence he took from me that night. Wouldn't take chemical tests, but took my badge and credentials. That doesn't prove intoxication. That just proves control. That's not how justice works, and that's not due process. The law requires, beyond a reasonable doubt, every contradiction, every missing record, every denied right that raises doubt. And here, that doubt isn't small, it's overwhelming. In conclusion, if this were you asking for the test that could clear your name,
Objection, Your Honor.
Overruled.
would you want to be convicted on contradictions and assumptions? Of course not, because that's not justice. The only verdict that honors fairness, truth, and the oath you took is not guilty. Thank you.
Sheriff is not impressed.
Oh, Lord.
Sheriff's not impressed by the whole proceeding.
She has 45 seconds left of her closing.
All right, ladies and gentlemen.
Why?
They both got 30 minutes total.
Oh, they got a time limit.
Yeah.
No way.
So she used 29 minutes and 15 seconds for her first closing.
Huh.
And only had 45 seconds left for rebuttal.
So they're sticking to it really that much.
Yeah.
Wow. It's like appellate court.
Yeah.
Huh.
How much time is he facing? The 4th degree felony is 6 to 18 months.
For what? For which part of the firearms?
Drunk firearms, yeah.
You're kidding me.
Up to 6 to 18 months. It can be less than that. First offense, so.
So he's got no priors.
I know he has no other felonies.
Sheriff is not happy.
And yeah, he only used like 11 minutes. Got in there, short, sweet.
Well, some people find it hard to do public speaking for a long time.
True.
She got 45 seconds, really? Cool.
Just as an example.
Bitch.
Yes.
You cannot, the fact that I just wanted to go to the front of the car and get my field sobriety test, he's not the one who's sitting there that night telling who to do what. He is the person who's under investigation. It was up to Sergeant Simpson. The whole idea that one was pulling me to the left, one was pulling me to the right, how could I have rolled over? That was denied by the deputy on the stand. So that is not evidence of what he was doing that night. Also, the fact that when you hear him, I'm complying, there's a reason why there's the old saying, words are not what you look at. Actions speak louder than words. In this case, I'm not hitting this podium. What is...
Can we just appreciate? She is literally doing the quote. If the facts are against you, argue the law. If the law is against you, argue the facts. If the law and facts are against you, pound the table and yell like hell. She is doing the literal quote.
Ooh,
she's pounding the table.
This is great.
It's true. My words or my actions? In this case, his words mean nothing. What were his actions that night? You have that. That's enough to convict this defendant beyond a reasonable doubt. And it's beyond a reasonable doubt based on reason and common sense. There's a reason that those words are used in there. I ask that you hold
beyond a
me to
reasonable
that
doubt
standard.
based on reason.
But the fact is, everything he did, his actions have convicted him in this particular case beyond a reasonable doubt. Thank you.
Ding, ding, ding.
Ladies and gentlemen, I've been a judge for about 20 years now, and in that time, I have learned that different people absorb information in different ways. And I'm going to give you the instructions of law now. Ms. Carrilco is going to give you a written copy of what I am about to tell you. So if you're one of those people that absorb information by listening and following along, you're going to have my script right there. It may be that not all of the exhibits that were referenced was able to exercise forfeiture if used or forfeiture using
how she's the one who lost her temper in this trial, and he didn't.
He never, in front of the jury or even during the trial, he never did.
No,
I don't think he really did
she's the
pre-trial
one who
much either.
huffed and puffed and went on and made a scene. He kept his shit together the entire time, really. Like, unless I missed, like, I didn't watch the entire thing. You tell me if I'm wrong.
No,
right?
he never. He was kind of scolded a few times, but that was just typical lawyers being scolded
for not understanding.
Or pushing the envelope a little bit, or just not, listening or doing what the judge says.
Sure, but in terms of just losing his temper and being a rowdy pro se, like criminal trying to be a lawyer kind of thing, and he didn't do that, right? Whereas she lost her temper a fair bit in front of the jury. It was slightly unprofessional a couple of times. It's interesting, isn't it?
Yeah, it is.
I don't think the jury's going to care, but
the jury's out at this point.
Maybe she was in need of a drink.
Physical.
All right, that's all it should be.
All right, I'll fix it.
Thank you.
Oh, she's definitely menopausal. I saw her having hot flashes before.
You could cut that sexual tension with a knife.
I'm still up there. I'm sorry. Oh, we on the record still? Sorry. Yeah, I was going to say.
Present before the court is Mr. Brown. Here today for
this
pre-trial. It's my understanding Mr. Brown's going to be entering plea of guilty. That monitor fee paid off.
Oh.
All right, I'm okay with that.
I don't know what the hell that was.
But my
person.
Yeah, the pink hair.
No. At the computer. Oh, I didn't even notice the pink hair.
It's a different inmate or an inmate or defendant. Sorry. After lunch, he sees a few people to take plea deals or whatever, or sentence them.
Okay.
So he's just squeezing a few people in throughout the day.
Woman, Paul, is it?
Yeah, it's a woman, I think. Oh, it looks like my friend's mom in high school.
It's a very strong jawline.
So skip this part. Skip.
Okay,
decide those counts and complete the corresponding verdict form.
Oops.
We have some disagreement in chat on whether that's a man or a woman.
The record in Mr. Riefers' case, it is now 3:30-ish. The jury has been deliberating for approximately 3 hours and 40 minutes. We received a question which reads as follows. Do we have to find the defendant guilty/not guilty on all counts? ? For example, we may find 2 we agree on and 3 we do not. Will this cause a hung jury? Given the length of time that they have been deliberating, it is my inclination to go ahead and give them a modified dynamite charge, which reads, I received a note from you indicating that you may not be able to reach a unanimous verdict on one or more of the charges. This is a new difficult assignment for you. The process of discussion and deliberation in the jury room is necessarily slow, requires consideration and patience. The secrecy which surrounds your efforts prevents others, including the court, from knowing when your efforts will result in a verdict. The answer to your question is no. You do not need to find the defendant guilty/not guilty on all counts if you are not unanimous as to those counts. If there are charges you agree upon, you should decide those counts and complete the corresponding verdict form. With regard to the remaining counts that you are not unanimous on, and then I go on to read them the modified dynamite charge.
No objection.
Anything from the state? Mr. Riefers?
No, Your Honor.
All right. Did we lose Mr. Elter, or do you feel like you need Mr. Elter here, or are you okay?
No, I'm okay, Your Honor.
Stand
All
by,
right.
counsel.
Go get our jury.
I did not write down Nate's phone number.
Yeah, this is what Bev should have read in the Karen
I
Reed.
got it if you need it.
What's she saying? What's she saying?
Did she, maybe she
He says he's all right. Oh, I got it.
I did not write down Nate's phone number because he said we need it.
Oh, I got it if you need it.
We need to, did she, maybe she
He says he's all right.
She needs a phone number. So jury's coming in to get the dynamo charge.
What's the prosecutor's name? Karen?
Ninawao said it earlier.
May be seated. Ladies and gentlemen, welcome back. I received a note from you,
Terry.
indicating that you may not be able to reach a unanimous verdict on one or more of the charges. I know that this is a new and difficult assignment for you. The process of discussion and deliberation in the jury room is necessarily slow. It requires consideration and patience. And the secrecy that surrounds your efforts prevents others, including me, from knowing when your efforts will result in a verdict. The answer to your question is no. You do not need to find the defendant guilty/not guilty on all counts if you are not unanimous as to those counts. If there are charges you agree upon, you should decide those counts and complete the corresponding verdict form. With regard to the remaining counts that you are not unanimous on, keep in mind that in a large proportion of cases, absolute certainty cannot be attained or expected. Although the verdict must reflect the verdict of each individual juror and not merely an acquiescence to the conclusions of the other jurors, each of you need to decide whether or not your position is correctly held. So you should examine your position with proper regard to the opinions of others. It is desirable that this case be decided and that all of the counts be decided. You're selected in the same manner from the same source and in the same process as would any other jury. There's no reason to believe that this case will ever be submitted to a jury that is more capable, impartial, or intelligent than this one. Likewise, there is no reason to believe that we would get more clear or different evidence from either side. It is your duty to decide the case if you can conscientiously do so. You should listen to one another's opinions with the disposition of being persuaded. Do not hesitate to re-examine your views and change your position if you're convinced that it's wrong. All jurors need to re-examine their positions given that a unanimous verdict has not been reached. Jurors for acquittal should consider whether their doubt is reasonable, considering that it is not shared by others. Likewise, jurors for conviction should ask themselves whether or not they might reasonably doubt the correctness of the judgment not concurred in by all the other jurors. It is conceivable, though, however, after a reasonable length of time, that honest differences of opinion regarding the evidence may prevent you from reaching an agreement on a verdict. When that condition exists, then you may consider whether further deliberations will serve no further useful purpose. If there is a possibility of reaching a verdict, you should continue your deliberations. If there is no possibility of reaching a verdict, you should advise me of that fact. So I'm going to return you to the jury room to discuss these options, and I'm going to send you in a note in a little bit with regard to your attentions. The note that I send in is going to ask you for yes or no. They're checkbox answers. Do not disclose any other information nor indicate the status of your deliberations. Ms. Kuroko is now going to return you to the jury room for further consideration.
And that's all fine, but I think the point was more they didn't understand whether or not if they didn't agree on all of the charges, whether that meant hung jury for everything. Right? Like, that was the question.
All right, we're on the record outside the
Did that
presence of the jury
answer the
in about 10 minutes. I am going to send them a note, which is going to say, do you wish to continue your deliberations today? Do you want to order dinner? Do you want to take an evening break? Do you wish to resume deliberations tomorrow? Or do you believe that further deliberations will not serve a useful purpose? And then each of them have a check, yes or no.
That's no objection. That's fine.
And then I'll have Ms. Kuroko let you know what the jury says.
I've never seen a judge ask the jury themselves if they can possibly go any further or not. I like it. It's just normally judges are like pleading with the juries, please, please, please keep deliberating. Please don't be hung, please.
Well, it depends. Like, usually at the first round of we don't know what we're doing, they tell them to go back. But this is the problem. Like, they're supposed to just say, did you hear what I asked before? Like, that's not what they asked. They didn't come back saying we can't decide.
Yeah.
They came back with a question.
Yeah, and he also, gave the Allen charge kind of prematurely.
Yeah, it's very strange. Like, he gave all this instruction when all they wanted to know was, if we can't decide on all of the charges, does that mean we're hung on everything?
Yeah.
He could have just answered that question and sent them back.
Yeah.
Yeah.
Okay. Like I said, that'll be in about 10 minutes.
Yes, the same. They just hang.
If they don't ring sooner.
Yeah.
They are an impatient jury. They rang 3 times before Ms. Kuroko could retrieve the note.
Oh, really?
So, all right.
Okay.
I'll keep you posted.
Thank you.
Okay.
Here you go, Ms. Kuroko.
I love it. The jury's so it's just raining for
Can I step out and use the restroom?
Yeah, we're off the record now.
I don't know. Can you?
May I? Choppers are coming.
Aww. Poor Terry.
Can you turn that off? That sound. It's super annoying.
Can't wait to get home and tell Mr. Mittens about this day. So then he comes back and they just sit there for like a little while.
Dolly.
Just awkwardly sitting there.
Dolly.
Hmm?
Chop the sound.
Oh.
Thank you.
Sorry. Hi, bye. I'll have to watch on replay group. Oh, hi, Dina. Thank you so much.
Hey, love.
This trial has been really good. I asked Sean a question about it. You might be interested in it. It's out of Ohio, and it's pro se, former policeman. And Jim, thank you so much for becoming a YouTube member. That's much appreciated.
Shut up, Justin.
Yeah. Oh. So. Oh, he's just playing on his phone.
He's pretty pleased with himself that he's
scrolling Facebook dating.
That he's like, I'm pretty sure I'm gonna not guilty on everything right now. So far.
Or at least some of it.
Yeah. She's like, I'm going to lose some of this to a pro se at the moment. This is just great.
All right, it is now 3:55. We have been advised by the jury that they have reached a verdict. Mr. Riefers, we don't have Mr. Elter here as your standby counsel. Do you want to wait for him?
No, Your Honor, it's okay.
Okay. All right, go get our jury.
Is he engaged now? Did he say that?
Oh, that's so sweet.
I love all the bailiffs in here now.
What a lucky lady.
Oh, he said in his opening. Okay, I missed that. Jury's all happy.
Happy chit chat.
Yeah, she didn't show up to the trial once. Maybe he would have been nervous in front of her.
Yeah, he would have been. It's okay, babe. I trust you.
Who's been selected as our foreperson? Is it Huntington?
Yes.
All right. Without disclosing the nature of the verdict, has the jury reached a verdict?
Yes, sir.
All right. You can hand the verdict forms to the bailiff. Ladies and gentlemen, were all of you able to follow my instructions and admonitions while you were deliberating? You can go ahead and sit down. Were you also able to remain free from any outside contact or any outside influence during the time that you were deliberating? We're just going to read the verdict forms as follows. We have count 1, improper handling of a firearm in a motor vehicle. We, the jury, find the defendant, Brandon Riefers, not guilty of improper handling of a firearm in a motor vehicle.
One down at least.
Verdict form count 2. We, the jury, find the defendant, Brandon Riefers, not guilty of using weapons while intoxicated. And there appears to be 12 signatures attached to each of these verdict forms. Count, let's see, I got out of order here. Count 3. We, the jury, find the defendant, Brandon Riefers, guilty of obstructing official business. We further find that the defendant did create a risk of physical harm to any person, and it is signed by all 12 jurors. Count 4, resisting arrest. We, the jury, find the defendant, Brandon Riefers, guilty of resisting arrest, and it appears to have 12 signatures. Count 5, OVI. We, the jury, find the defendant, Brandon Riefers, not guilty of operating a vehicle under the influence of alcohol, drug, or abuse, or a combination of them both.
Suffer!
Oh, look at her. He's so dejected.
You silly cow. I'd love to see ogre couple now.
Yeah. So improper handling firearms, that was the biggest one. That was a 4th degree felony. Not guilty. Using weapons while intoxicated, misdemeanor, 1st degree 1. Not guilty. So he was guilty of the obstructing official business. That's a 5th degree felony.
Damn.
I vaguely remember Sean say, "Oh, I will." Okay, saying that you still keep your gun rights on a 5th degree felony in Ohio.
Really?
But I need to get clear. I DM'd him for clarification. I haven't heard back yet. Because it's like not as severe. It's the way they do is weird. Resisting arrest. Oh, we're kind of covering this. Sorry, guys.
Is that a felony?
No, resisting arrest is a 2nd degree misdemeanor. Okay. So those 2, and then OVI misdemeanor 1st degree is not guilty. So he's like facing.
So he's got 1 felony.
Yeah, 5th degree. The not as the least severe. It's not good, but.
So what's the penalties?
For a 5th degree felony, I just looked this up. Up to 6 to 12 months. or potentially
Mhm.
probation, a judge may place a defendant on probation instead of jail time.
Yeah.
So
So we think this judge is an ass. You might put him in jail.
well, we'll see.
Yeah.
Ladies and gentlemen, are those your verdicts?
Yes, sir.
All right, does either side wish to have the jury polled?
No,
Ms.
Your Honor,
Hyatt, Mr. Riefers?
No, Your Honor.
All right, ladies and gentlemen, this concludes your service for us here. I do want to thank you again for your service. Ms. Kuroko is going to take you back to the jury room, reunite you with your electronic devices. I'm going to come back here and talk to you for just a couple of minutes. You are now released from all of the instructions that I have previously given you. You can discuss this case with anyone, but you are not required to do so. Thank you again for being here.
All the bailiffs don't know what to do.
All right, the court is going to accept the jury verdicts in the case. Ms. Hyatt, you will send me an entry with that regard.
Yes, Your Honor.
I am going to set this matter for sentencing. That's going to take place in about 8 weeks. Anything else, Ms. Hyatt?
No, Your Honor. Thank you.
Mr. Riefers?
No, Your Honor.
All right. You behaved yourself all during this trial, Mr. Riefers. Generally speaking, I take somebody into custody after a jury trial. I've almost always done that. I'm not going to do that today. You behaved yourself, and honestly, I have no idea what I'm going to do in this
The
case.
bailiff just
leaves. I am going to kick
Okay.
him out on
I guess we're
pre-trial
done.
during the
They
time
all leave.
between now and sentencing.
Hi guys.
Ms. Kuroko will probably. No, oh, Ms. Idle's still here. Mr. Elter and Ms. Hyatt, why don't you go see Ms. Idle and get a date, and then let Mr. Riefers know what that date is. I only do that for security purposes back in her office, Mr. Riefers. I don't want you back there. We'll get a date that works for everybody. That'll take place in about 8 weeks. Then you need to, I would like you to come back up here either tomorrow or the next day and fill out the paperwork for the PSI. They're going to be done back there for today. Okay?
Yes,
All right, go see Ms. Idle and we'll get a date.
Yay!
Oh, Mr. Elter, we're not guilty on 1, 2, and 5, guilty on obstructing and resisting. All right.
Thanks for turning up,
recess.
buddy, Mr.
I'll
Elto.
make sure that Ms. Idle is still here. You guys can talk for a little bit if you need to.
He did great. Nice job,
Yes.
Brandon.
Could have been. That was a win because he didn't get the 4th degree felony.
What a bloody
Yeah,
legend.
It sounds like the jury was split between was he drunk or not. And I'm thinking that they compromised just to get the verdict done.
I don't know if that's not necessarily true because all they asked was whether it would be a hung jury all over if they couldn't decide on if they couldn't decide on all of the charges, right? So they might have all agreed that they couldn't prove that he was drunk.
Yeah.
So that might not have been an argument at all. So therefore, their question to the judge was, if we don't agree to guilty on 5 charges, does that mean that it's a hung jury? You see?
Yeah.
So there might have been no question about the fact that they agreed, all 12 of them, that 2 charges were guilty and 3 were not guilty.
I see.
Yeah. I think it was
Be
pretty
interesting
obvious
to-
that they couldn't prove that he was drunk.
I mean, you'd have to take the word of the people he was with that day. Because under
Yeah.
Ohio law, you don't have to test somebody. You can use like the testimony of others, like what they witnessed, to infer that the defendant was drunk.
Yeah.
It's a lot harder to prove, though.
It's still like it doesn't meet beyond a reasonable doubt, does it?
I do not think it does, but
No.
that's just
I
my
mean,
opinion.
But jury's for jury. And I mean, I would have thought that from what I know of juries, that they generally will be like, okay, cool. They say he's drunk.
Yeah.
Fine.
Well, this place is weird. Juries here are very weird.
They can prove he was, yeah, you're right, Justin. They can prove he was drinking. They can't prove he is over the limit. Exactly. And I think it's 0.08, right?
Yeah.
And yeah, 0.08 is decent. Like here it's 0.05.
Yeah.
But 0.08 for a man that size.
Yeah.
Is a few drinks. I think it's almost 3 in 2 hours.
That he had?
No, you have to have had 3 in 2 hours, 3 standard drinks in 2 hours for it to not be eliminated out of your bloodstream. Yeah. To hit the 0.08. Oh, here it's 0.05. Right. So I would think, that they would have need to have seen him ingest 3 standard drinks in the 2 hours before he got in the car to put for the testimony to stand up to beyond a reasonable doubt.
Yeah,
and then
the food they ate, that is because they had a couple meals. So it was just lazy police work.
Yeah.
All they had to do was test him. He wanted to be tested. And
yeah, Justin, it wasn't like he was way over. It wasn't like they'd seen him all day just drinking and drinking and drinking like a fish.
Yeah. And I don't know, how much of it was they talked afterwards and what they saw, they each kind of fed off each other and twisted it into this whole narrative, not intentionally, but they all start thinking the same thing kind of, and it becomes a lot worse, or his behavior was a lot worse than actually happened. I don't know, but it just felt like there was a lot of malevolence there.
I hated him.
I think he did slur his words a little bit, but so yeah, buzzed, but it's just they were not. Yeah, Ashley and Lindsay weren't credible at all. And it doesn't help that she has a traumatic brain injury.
Which one?
The girl he was with that night.
What does she? I never saw her testify. I missed her.
Oh, yeah. She was in the military, thank you for your service. But when she was in the military, she got a TBI. So their star witness has a brain injury.
Right. I thought all of them had brain injuries, to be honest.
Wow. I mean, wouldn't surprise me.
Yeah. Birth defects. That was an ogre couple.
So you doing anything tomorrow?
I doubt you'll probably see me until maybe Sunday because I have an assignment to get in and it's my brain is falling out through my face right now. So I really should be working on it at the moment. But I couldn't help myself.
Yeah, this was fun.
It was. Yay, Brandon.
Okay, guys, I'm going to end now. This has been a lot of fun. I'll be back tomorrow for Courtroom Roulette at 10 o'clock a.m. Eastern. And I'll probably do another trial next week as well, probably Wednesday. So keep an eye out for that. So thanks, guys, for hanging out here, and I will see y'all tomorrow.
Bye, guys.
Bye.